To mention, my lord, this matter, my lord, these four matters are analogous matter. And my lord, I mentioned before your lordship in the month of June. And my lord, your lordship allowed it. And my lord, it appears in the daily list. And my lord, on 28th, my lord, June 2023, my lord, it appears with 28th. And my lord, on that very day, your lordship did not see it, and therefore, my lord, it goes down. My lord,
Give the number.
And may I be permitted to mention, my lord?
My lord, may I permitted to mention?
From the month release. These are identical matters, but the scheme has been abandoned or land is not released from the requisition. Nine matters.
My lord,
same issue.
my lord, may I?
My lord, may I permitted to mention, my lord? My lord, may I permitted to mention, my lord, no urgent matter, my lord. My lord, demolition order has been, my lord, date has been fixed, my lord, 23rd. My lord, kindly, my lord, give leave to, my lord, move this application today or, my lord, tomorrow, my lord. My lord, kindly see page 49.
File and give the number.
My lord, what happened, my lord, if my lord file the matter, my lord, number has been supplied, matter not sending that computer filing department. They said that, my lord, unless the leave has been granted, the file will not set.
Urgency, sir.
My lord, kindly see, my lord, page 49, my lord.
My lord, may I be permitted to mention this matter, my lord?
I have not.
Kindly see page 49. My lord, National Highway Land and Traffic Act, my lord, order has been passed. Then, my lord, appeal has been preferred. My lord, during the pendency of the appeal, this notice has been served that 23rd is the for demolition. My lord, there is a statutory appeal. My lord, the private respondent, my lord, a writ petition in the earlier writ petition, they moved the writ petition. My lord, contempt application file, there is a contempt application that statutory appeal, disposal of the statutory appeal, National Highway Land and Traffic Act, then, my lord, they will take steps.
Compliance with that order of a coordinate bench that this order has
That
been
one,
passed.
that bench is not, because of contempt application is disposed of. Your lordship has a now jurisdiction in the land, National Land Traffic Act. My lord, these persons is, my lord, National Highway, my lord, long ago, my lord, they have not the roadside. Not only that, my lord, writ petition and, my lord, suppressing fact.
I'm sorry, sir. File and come back. Give them.
My lord, may I be permitted? My lord,
My lord.
Yes. Hearing matter. Give the number.
May I have your lordship?
upgradation.
Hearing.
But may I have your lordship's leave?
Hearing matter.
But
My lord,
Listed out.
may I have your lordship's leave, my lord, to mention these two matters. My lord, hearing matters. My lord, my lord, these matters, my lord, lordship, in fact, on 2 occasions, being pleased with the urgency, was pleased to fix one matter of them as item number 1 in the supplementary list. Because of adjournment, my lord, it has gone down by the state. Now, my lord, in both these matters, both are appearing in the monthly list. Both these matters, my lord, the government has put in the notice board saying that this land has been, I have challenged the resumption, but board has been put in. After your lordship's direction, again, it has been done. My lord, if these are not upgraded, my lord, I will be dispossessed.
It will come in the supplementary list. Give the numbers. Hearing matters.
These are hearing matters, they are appearing in the monthly list, my lord.
Supplementary.
my lord, may I be
Definitely.
permitted to mention this matter for upgradation, my lord?
My lord.
Well, let them appear in the supplementary list.
Monthly take a supplementary.
Well, let these appear in the supplementary list.
My lord, may I be permitted to mention this matter? Sorry.
Tell me what is your. Please tell me. Yes.
স্যার আপনি এবার মেনশনটা করে দিন আগে।
Give the number. Give the number, please.
May I mention one matter for upgradation?
My lord, may I be permitted to mention this matter for upgradation, my lord? It is running as item number 41 in the monthly list.
Mention according to seniority. Please allow the learned seniors to mention first.
Long time I am waiting, my lord.
Give the number.
Restoration application.
Restoration application. Give the number.
Contempt.
Restoration. is-
Restoration. Any restoration application. Restoration.
I'm not able to hear you at all.
Only thing is there is a land matter compensation.
Restoration আর এটা নিয়ে কোনো mention করার দরকার নেই। Mentioning ছাড়া restoration আর এই ছাড়া নেবেন না কিছু। Only restoration and contempt without mentioning.
Without notice, we give notice to the other side. My lord,
My lord, with
I am paying my lord's inclusion in the
Please
list.
take the microphone. I'm not.
May I see?
This is a situation where, my lord, my client has many a time mentioned the matter where, my lord, the compensation is not being paid, but land has been acquired. And, my lord, land has been also acquired without any real award. And my lord heard the matter several times, my lord. One order was passed by your lordship. There are
Hearing matter or at the motion?
hearing matter, but, my lord, item number 1209, my lord, your lordship appreciate, my lord, this situation
Give
is,
the number.
my lord.
May I see my lord's kind? May I
My lord, I am mentioning, my lord, put a notice to the other side.
What is
Item
this?
number 686 of the combined list. My lord, there is some urgency, my lord, they are constructing, my lord, before my house over a
Give the number.
PWD.
Give the number.
May I seek?
My lord, may I permit it to mention, my lord?
Common land, my lord.
Give the number.
And the new motion, my lord, new motion, my lord. New motion.
Yes, madam, have you mentioned the matter?
Yes.
What is this matter about? Yes, I can see a slip coming from behind. Yes, what are you asking for?
2019, my lord.
Yes,
Land matter inclusion for land matter.
1 minute.
Government memo.
So why are you giving the slip without mentioning?
With you, not.
I have seen the entire situation, sir. Please come back tomorrow.
May I seek my lord's?
Come back tomorrow.
My lord, new motion. My lord,
Fair dispute to part, sir.
I have taken notice, my lord.
আপনি যেগুলো mentioning ছাড়া আপনার হাতে আসছে নেবেন না, সাইডে সরিয়ে রাখবেন।
May I seek
my lord,
my
may I
lord's
permit
kind
it to mention, my
indulgence?
lord? Last Friday, my lord, I have mentioned one matter. Your lordship told that, well, give the number, matter will appear today. Well, matter is not appear. My lord, kindly, my lord,
Give the
Please.
number.
May I seek my lord's very kind indulgence?
top of the list, my lord, other. My lord, motion, new motion.
New motion, give the number.
First, may I seek?
Yes.
বলেছে
For what? Upgradation for what?
motion, my lord.
Disposal of the
What is your urgency?
Matter is short, my lord.
Yes,
3 months, it is not,
please take the microphone. I'm not able to hear you.
735 and add 0. So
Please take the microphone. I'm not able to hear you.
My lord, pardon, may I permit to
Please allow him to say.
yes, my lord, item number 735, my lord, it is upgradation, my lord. My lord,
What is your urgency?
appeal has been preferred by the respondent number 8, my lord. That is pending for long, my lord. So, my lord, kindly direction upon the,
Appeal against what?
against for this order, high court order, my lord, he has preferred appeal.
Appeal against which order?
Against, my lord, have passed the order, my lord, sometimes in March, my lord.
Appeal against my order, appeal pending. I'll ask them to dispose of the appeal.
Preferred appeal.
I do not follow you.
No, my lord,
Appeal against whose order is pending?
district magistrate, one appeal has been filed before district magistrate, my lord. That is pending.
Against which order, sir? Against which order is the
That
appeal
order
pending?
is not with me, my lord.
Please come
May
back.
may I seek? May I seek my lord's kind indulgence?
State motion, my lord, since 2022, my lord, it's been pending. My lord has reached twice, my lord, KMC did not appear. My lord, what is doing now KMC? My lord, KMC is encroaching into my land without any valid
Give the
acquisition.
My lord, extension of interim order.
Motion, my lord, motion. 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 আরে বললাম
Give the number.
May,
Give the number.
may I seek my lord's? May I seek my lord's kind indulgence? To,
Sir, I think I've asked you to come back tomorrow, just now.
May I be permitted to mention?
I think I've asked, no, sir, discipline should be maintained first. No, I'm sorry. I am sorry, sir. Please come back tomorrow. I will not take your mentioning today. Maybe, but you should maintain discipline first. I'm sorry, sir.
My lord, I am.
Do you want me to repeat? Do you want me to repeat what I said? Not at the cost of the discipline of the court, sir. I'm sorry. You're passing the mentioning slip through someone else. No,
May I seek,
Yes.
Listed motion, listed motion.
It's the monthly list.
No, they are not appearing in the list.
Give the number.
may,
Unfortunately, my lord, as her land was taken over without any compensation. I mentioned this matter, the matter was appearing in the list at 872 in the monthly list of July, my lord. My lord was pleased to allow my appeal, and my lord matter was listed at 101 in the month of July. My lord, then my lord, again, in this combined monthly, again, the matter was transferred to tax serial number
Give the
870.
number. Give the number.
may I seek,
My lord, my lord, my lord,
Give the
my
number.
lord,
Listed motion.
Yes.
চালাচন করছে এক কথায় নেবেই না জোসেফ তুমি বলছো বারবার নেবেই না বলছে কাল নেবো কালকে যান বলুন
No need.
তা আমি কি করবো
What is your case? Give the number. Give the number. Give the number.
may I seek,
Give the number.
may I seek my lord's kind indulgence to mention one matter. My lord will recall that matter. With the wires of Murshidabad, the state has been challenged, my lord. Repeated opportunities have been granted to the state, no affidavits filed till date. My lord, extension of interim order, my lord, it's expiring, my lord.
My lord.
But there is one,
Extension of interim order.
non-prosecution, non-prosecution.
কিছু করেনি, আমি বলেছিলাম আপনাকে গত সপ্তাহে হবে। গত সপ্তাহেই তো বলেছিলাম আমি, তাই তো হবে।
my lord, extension of,
My lord, extension of interim order.
extension এটাই।
My lord, let me make one thing very clear. I'll include everything in the supplementary list, but under no circumstance will I upgrade matters of the supplementary list. If you are still agreeable, please continue to mention.
My lord, item,
Everything is included in the supplementary list. Let it go down to 1,000. I will not upgrade any matter of the supplementary.
my lord, item
Make it very clear.
my lord, item number,
Yes, yes, give the number.
my lord, item number 10,
Give the number.
item number 1064 of my lord's monthly list, it's under group 1 hearing matter, my lord. From 2018, my lord, matter is pending affidavits complete. The grievance is that UD department is claiming a sum of rupees 24 lakhs for causing mutation. I'm also grateful, lordship.
My lord, my lord,
Grateful.
Non-prosecution.
non-prosecution to be mentioned. More than 60 matters have been taken. If you still want to mention, you can continue.
My lord, new motion, Lordship. My lord, upgradation, my lord. Upgradation.
Yes, give the numbers, give all your numbers. All will be included, but no upgradation further. Give the numbers.
My lord, দিয়ে দেবো তখন আবার ওই আপগ্রেডেশন এটা
What is your urgency?
বলছি তো এটা তো আমার মান্থলি লিস্টে আছে
Give the number.
May I be permitted to mention, my lord? My
Yes.
lord, in the monthly list of 751, it is appearing, my lord, for upgradation, my lord. The respondents is trying to encroach the national highway property, my lord, creating problems in the ingress and egress of my property.
Give the number.
My lord, my lord.
Yes.
And the matter is regarding to the production hampering in the non-supply of Jhama coal
I do not follow.
for hearing matter, my lord.
Affidavits are exchanged.
No, my lord.
Then come back after exchange of affidavits.
My lord,
Permitted to mention matter, listed most.
What are you asking for? It's in the supplementary list or monthly list. Give the number.
With my lord's kind,
list, my lord, upgradation, my lord. Monthly list.
What is your urgency?
My lord, my land occupied ECI for water pumping, and he is not pay any money of my petitioner.
Give the number.
My lord's kindly. Chalo, chalo.
Yes.
I'm sorry for late, lordship. I'm mentioning item 24 of the student list.
Today's list, please do not mention.
Minutes,
Today's list, I'll call. Please,
Very
I'll.
To mention, Lordship, the entire land of the petitioner has been acquired by the government, Lordship, and no, till date, 44 years back, Lordship, till date, he has not received a single penny. He's 88 years old, Lordship.
Give the
New
number.
motion.
Releasing the matter. Vivek,
I am for the.
we mentioned release.
Lordship, in the KMDA accepted the fees for installation of hoarding. I have paid entire amount. Now KMDA say the money can be refunded, this contract is cancelled. In the meantime, also urgency is that this is the entire medical reports of my client. He is a cancer patient, is now is counting days. Lordship, let this matter be heard. Lordship, at least it is running in item number 830.
It's at the motion stage.
It's a motion stage.
Give the number. देखे तो दिन रिलीज बोलो तब देखो.
Listed motion. This matter was lastly taken up 8th August. Before the Honorable Justice Jaysingh Gupta, his lordship, he has directed the matter to be appear under Group 1. Mistakenly, it has been filed under Group 9.
Give the number.
Lordship,
My lord,
may I take your lordship's kind leave to mention
my lord,
one
kindly
matter?
may I be permitted to mention a matter, my lord. There is a sheer urgency involved in this matter. This matter was filed in the year 2022, my lord. Entire building of the writ petition has been demolished. He is staying in the rented premises, my lord. The matter did appear before your lordship. My lord directed me to file an injunction application that has been filed, but during the pendency, entire building premises has been demolished. They are now staying in a rented premises, my lord. Until and unless this matter is
Lordship, may I take your lordship's kind leave?
two matters,
Leave
my
to
lord.
men-
Two matters.
To be mentioned non-proceedings.
Lordship, item number 1054 of the monthly list, Lordship. It was previously mentioned several times. Your Lordship were directed to upgrade this matter. It has not been upgraded. The urgency is a very urgent matter is that the private bond of the petitioners are being encroached by these private respondents. There was an injunction order filed by us, and the injunction was granted in our favor also.
By
But
the writ court.
no, Lordship, the civil court, Lordship. That matter has disposed of. Lordship, this matter was.
Private dispute.
Lordship, the encroachment done by the private respondent, this intimation has been given to the municipality also. They are not acting over this matter, Lordship. Kindly hear this matter, Lordship. It's under a hearing, Lordship.
Hearing.
Yes, Lordship.
Affidavits are
Yes, Lordship.
exchanged.
Yes,
Give the number.
Lordship, may I pay for your lordship's kind leave?
May I be permitted to mention on matter, my lord?
Will you please come back tomorrow for the rest of remaining mentionings?
This matter,
About 100 mentionings have been taken already today.
this matter, your lordship was directed me to mention after returning from the lordship, the circuit brings that matter of the
Will
metro
you
rail,
please come back tomorrow?
that matter, metro rail works
Can
matter,
vote
my
in
lord.
100 matters for mentioning today. So I believe it will really help you if so many mentionings are
mention-
taken.
My lord, one matter, my lord.
Why? This matter has already been heard by your lord. In the hearing, the respondent accepted suspension of the by handing over a document issued by the government employer. Then your lordship was pleased to directly to file an affidavit incorporating that document. But my lord, once that past no affidavit has been served, let the matter be placed under any circumstances so that matter may be on the basis of that document is being kept with your lordship.
Give the narrator to be mentioned. Rakhu.
My lord,
Yes, remaining mentioning tomorrow.
my lord, may I mention one extremely urgent matter.
Tomorrow, sir.
My
One day,
lord,
heaven
kindly
will fall.
hear me for a second. Last week, when I mentioned the matter, I should remember that the DM has issued an order to demolish my shop or the room. Now that is pending before your lordship since last 2 months. Extremely urgent.
What difference will it make if you come back tomorrow, sir, for the
No,
mentioning?
they are going to demolish my everything
When?
tomorrow. My lord, I mentioned it.
Sir, please show me the order. That they'll demolish tomorrow.
Yes.
Please
Then-
show me the order.
I show my lord, can you let it be, keep it to tomorrow, at 2 p.m. I will bring that order.
You are mentioning a matter
No,
without a
Madam,
document.
my car got punctured.
You
There's a
come
letter
back
in my car.
Tomorrow,
my-
10:30, I'll
But I
take
shall at 2 p.m. my lord. It's there.
10:30, I'll take it, sir.
Your Lordship, this is for contempt application.
Tomorrow it will be
For contempt application.
Application, give the number.
And I will mention at 2 p.m. my lord. I do this.
May I mention, my lord, one matter in the month?
At
10:30, I said,
10:30
tomorrow.
tomorrow.
I just wanted to mention only one matter, in the monthly list. It is fixed as 12:30.
You have heard what I've said, sir. Please come back tomorrow. at
My
10:30.
lord, in item number 1, lordship. Regarding
Yes,
item number
item number
1,
one.
lordship, my lord, matters come at my instance, lordship. On last Friday, when I came, Lordship directed me to serve notice upon the other side. Accordingly, I have served notice upon the other side.
You are
My lord, kindly see the
সোমবুধ শুক্র নিউ মোশন আগে আসছে না কেন? সোমবুধ শুক্র নিউ মোশন আগে আসছে না কেন?
এটা নিন।
আজ থেকে সোমবুধ শুক্র নিউ মোশন করুন।
Your lordship passed an order on 27th of July.
Yes,
My
what
lord,
is the
kindly see
correction?
the order, lordship. My lord, there are apparent 4 typographical mistakes. I have,
What are they? Please point out.
my lord, kindly see, I have stated in paragraph 2, lordship, the
Yes.
petitioner and the private respondents, it should be state respondent. Because I appeared for the private respondent, my submission has been recorded in the very next paragraph, lordship. It was typographical mistake.
Oh, it should be state.
Yes, it should be state respondent instead of private respondent. My lord, kindly turn to page 2
Yes.
of the order. My lord, the second paragraph,
Yes.
since the applicant is admittedly to a co-sharer, it should be claiming to be a co-sharer, as because in the very first paragraph, lordship, since we pointed out, added as party respondent writ petition on the ground that he claims to be a co-sharer. Second line of the first paragraph. Kindly see, since we pointed out, my lord recorded
There
the
was
same.
no dispute with regard to the fact that he.
My lord, that is why in the first
So
paragraph,
this is correct. This is not wrong. This is correctly recorded.
my lord, it is totally contradictory to the first paragraph and the second page line. Kindly see the claim admittedly.
Why is it contradictory?
That part is your
No,
Lord's contention
let,
is.
my lord, kindly see, he claims to be a co-sharer. He claims to be a co-sharer.
Foundation of my application.
That is since we pointed out, that's why my lord, instead of admitted, my lord pointed out he claims to be co-sharer.
Right.
The very in this paragraph also,
It's correct. This is not wrong. Because he is admittedly a co-sharer.
my lord, in that case, the first paragraph is also incorrect, lordship. Because we raised this point.
Yeah, this, no. This is, this is not a typographical mistake. I have consciously dictated this.
Yes.
So if you are.
I was there, my lord, I still remember that is your lordship's
This is, I have consciously done, dictated.
Well, since it is.
What is the next correction?
My next one is the second
Correction is
paragraph.
only for typographical mistake, isn't it? Not a correction of a conscious decision. Next, what is your correction?
My lord, the second paragraph, fourth line,
This is also perfectly all right. No correction is necessary.
and
Next.
lordship, the last line, there shall be no order as to cost.
Oh, that no is missed out.
Yes. My lord, kindly appreciates
Please
in
do.
the
I
first
will not
paragraph,
appreciate
lordship.
on
My lord,
merits,
kindly
sir.
appreciate in the very first paragraph, lordship. My lord, since added as
This
part,
is my considered
he
view.
claims to be
Yes.
co-sharer.
So
Faithful to
this
lordship.
is
That
my
was your
considered
lordship's
view.
view.
This is not a submission made.
My lord was going
You are
to
asking
insert
for
the word
correction?
admitted.
No, no.
Since we pointed out, he claims to be a co-sharer.
He claims. to
Only
be-
this much.
This is the considered view of the code. You cannot ask a correction of it. This is not a typographical error. It's a conscious decision. The matter has come up under the heading to be mentioned at the instance of the private respondents. Paragraph, inadvertent error has crept into the order passed on 27th July 2023. Paragraph. In the second paragraph of the first page of the order, the private respondents be read as the state respondents. Paragraph. In the last line of the second page of the order, the line, inverted comma rakun, there shall, comma, however, comma, be order as to costs, inverted comma close korun, be read as, there shall, comma, however, comma, be no order as to costs. Paragraph, the department is directed to incorporate necessary correction accordingly. Paragraph, this order be treated as part of the order passed on 27th July 2023. Paragraph, urgent certified website form.
Grateful to lordship.
Namdi, Dilam two.
Next.
My lord, in this matter, I beg to appear for the petitioner. My lord will remember, my lord, this is this matter, my lord, the contempt application, my lord, where the state preferred a review. Mr. Shengupta was appearing.
Yes.
My lord, twice they have withdrawn it as some. My lord, today it is appearing as a contempt application.
In this matter, Mr. Sushobhan Singh appearing for Alice
Yes.
contemner, my lord. He is on leg code number 5, my lord. I'm playing short pass over.
So there is no review application. Have you complied with the order under
My
contempt?
lord, review application was dismissed as per my lord's direction,
So-
but my lord, state will prefer an appeal, my lord, but certified copy not received.
Review application was dismissed as withdrawn. You have
Yes,
withdrawn
my
the
lord,
review
but
application.
review file has not sent down, my lord. Certified copy not received in this, my lord. That review application, my lords, that is not sent down, my lord, by the department.
It was withdrawn on your
Yes.
prayer.
Grateful lordship.
So you want to prefer
That
an
is
appeal against
pending.
that order?
But my lord, review certified copy not received due to the department file has not sent down to the department, my lord.
Let there be a date. Let us see what they do.
My lord.
Let there be a date. He wants a certified copy of the order.
Yes, my lord.
My lord,
দিদি
State will file appeal.
ডিপার্টমেন্টে পাঠিয়ে দিন আজকে ফাইলটা ডিপার্টমেন্টে পাঠিয়ে দিন আজকে সার্টিফাইড কপি নেবেন
But the matter is, my lord, the matter is unnecessarily being dragged by the
I know.
state, my lord.
I know it is being unnecessarily dragged. Let us see how far they can drag.
My lord.
A shorter accommodation if
CPA in order হবে on prayer of the alleged contemner the matter is adjourned. Paragraph, let the matter appear under the same heading on fifth September. Paragraph, affidavit of compliance be submitted on the adjourned date positively.
Grateful.
File to name again. Next.
Item 3.
I'm for the applicant, Lord.
Disposed of by passing an order, my lord.
I filed one recall application. Lordship had submitted notes of argument, everything.
Yes, can 2 is filed, my lord, for recalling of an order of dated 29th September 2021, my lord.
Yes.
Where your lordship was pleased to pass an order allowing the writ petitioner to take back the rest of the back wages. My lord, there are grievances in the can 2 applications, my lord, that we have entered into a settlement and accepted 40% of the back wages. My lord, that was disputed by filing affidavit in oppositions. It was heard in 2 occasions, my lord. I was led by Somo Majumdar, my lord. The things was placed.
The application গুলো বের করে দিন তো। Application or affidavit in opposition.
And also the writ petition, my lord. They have the primary of
Spread কাজ করছে না। খবর দিন।
Can 1 and 3.
Two.
can number 2.
খাতা করছে application। All the parties are appearing.
Yes,
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 State, the
yes,
Union of
all the
India and
Can 2 of 21.
yes, yes.
state
20.
is not a party.
No.
Because the display board is not functioning outside. That's why I'm
Yes,
asking.
But despite of the service, my lord, trade union has not been appearing. My lord, their appearance has been noted, my lord. I mean, their letters has been noted during the course of hearing, my lord. If I may allow to place before your lordship the page 626 of the writ petition, my lord. That's the first letter where I approached the trade union leader. I mean the respondent ECL, my lord. I approached the ECL to settle the matter as quick as possible. My lord, the award was passed in my favor. Their objections in the ALC, my lord, has been rejected. I have been awarded for entire back wages and the rest and the restored to the service. My lord.
The writ petition.
My lord, the thing is this, thereafter I retired from the service and prayed for back wages, full back wages. my lord, I file an approach and letter and serve a letter to the respondent authority at page 26 of the writ petition, my lord. That is the letter of 11th May 2023.
Writ petition page?
Page 26. Page 26 of the writ petition, my lord. There I approach the respondent director personnel, praying for the early settlement of the dues.
These documents were considered when the order was passed.
Lordship, I'm extremely
So
grateful.
what is the
Lord, the
recalling
grievance
application?
is this, they have come forward with an application, They have come forward with an applications of CAN 2, my lord, where they have relied upon a letter allegedly signed by me. My lord, the thing is this, that particular letter is at page 34 of CAN 2.
Page 34.
Page 34.
Yes.
Page 34 of CAN 2, my lord. This letter is disputed. They are saying it is of 2013, my lord. We have issued a letter on 11th, and just after a few days, what was the occasions, I do not know. My lord, they have come forward with an letter in the CAN 2 applications by saying that I am authorized the trade union leader to accept the 40% in lieu of the entire back wages. I do not know what was the occasions, my lord. My lord, that letter was disputed, and by filing an affidavit in oppositions, my lord, I have also raised objections that this is not my letter. The contention is not known to me. My lord, after 2 years, my lord, after 2 years, in the year 2015, my lord, if your lordship kindly take the page 30 of the CAN 2, my lord, there's a minutes of meeting, my lord, handwritten. There, my lord, this particular letter was disputed by the workman, my lord. Though I have disputed the minutes of the meeting, my lord, it is at page 30 of your lordship brief.
Yes.
My lord, it is in a handwritten of minutes of the meeting, my lord. On raising on my applications, on my prayer, the RLC, my lord, summoned the meeting. They are saying like this. It is alleged minutes of the meeting.
Was held in 2015.
2015, after 2 years.
2013.
13. And after 2 years, why the delay? I do not know. At my cost, when the gratuity was not paid, I reported, I complained before the RLC, and they summoned me. And during that period, they were asked to issue all the letters, and they concocted this story that this things has been settled in the year 2013, and come forward with a letter of 19th May 2013, my lord. It is a minutes of 2015. And if your lordship kindly consider the handwritten things, my lord, on page 30 at the letter page, in the last paragraph of page 30, my lord,
yes,
the 19th May 2013's letter was mentioned, and thereafter it is also mentioned the signed by him, but he did not know the contents. My lord, thereafter, my lord, the minutes of the meeting proceeded by relying upon the 11th May 2013 notice, my lord. That's my notice. That's my notice to the director personnel praying for early settlement. There was no authority has been given to the union leader to settle the dispute at 40%. There is no agreement between these things. 2 years has been passed. Who has settled the things? With the employer, not the employee, a trade union leader. He was party. Service was made, but they never bothered to appear before your lordships to support them. Neither the respondent number 2 nor the respondent number 3. Both were summoned. Then, after considering the entire material, my lord, your lordship was pleased to pass the order. But the Union of India was there. Union of India
supported your case.
Yes, Union of India said that the award was passed. It was advertised accordingly. Award become final, so it has to be implemented. And we have received the money, part payment, my lord, in the year 2013. It's an 8 lakhs rupees, if I'm not wrong. We have received,
The employer did not contest the writ petition.
Lordship.
The employer did not contest the writ petition.
No, initially not.
File recall application.
First occasion, my lord, before my lord Justice Amrita Sinha, they appeared. But despite of directions of the affidavit in opposition, suddenly they disappeared. And in number of occasions, if your lordship kindly consider the records, my lord, in number of occasions they didn't appear, despite notice. The moment I serve the contempt notice for the contempt application, they become very agile and file the. And not only that, if your lordship kindly consider the records, they filed the can too, but they didn't bother to move it. After receiving the contempt applications, my lord, they come forward and saying that we have filed the can 2 applications. Where the fact remains, my lord, the admitted position is this: I have received the part payment of the back wages in the year 20th July 2013. It is not disputed fact. And what was the occasions to come forward before the RLC with the minutes, with the letters? It's an everything.
The labor court order was not challenged by the employer.
No. Now they are trying to reopen the entire thing by filing these can 2 applications and etc. Kindly do not allow them, my lord. And it is well considered order, my lord, at the instance of the Union of India, where the point of law has been argued and all these materials, whatever has been disclosed before your lordships in the writ application, all things has been considered. And it is your lordship's conscious decision. And no paragraph has been spent, my lord, no paragraph has been advanced before your lordships, but to show as to why this ex parte, I mean this order will be recalled. There is no ground. Only the things is they settle at the 40%. 19th May letters was not forwarded at the time of 2013 meeting. It was forwarded in the year 2015. And my lord, surprisingly, my lord, if your lordship kindly consider the their can 2 application at page 33, if I'm not wrong, that's the page 33. Page 33. It's a letter of trade union. Between the union and the general manager.
Page 33.
Page 33. It's a better typed copy is at page 33. Mala. 32 is the original letter. Photocopy of the original letter. It is a letter of 2015, and I have received the part payment in the year 20th July 2013, my lord. What was the occasion? And my lord, kindly see in the page 32, there is an endorsement of the general manager.
Page 33 doesn't really mean anything because this is not the petitioner's letter. It is from the general secretary to the.
Yes, who authorized him? Who authorized him to take? Who authorized him to write this letter to the director personnel, general manager? And that general manager promptly, if your lordship kindly consider the page 32, my lord, once. Here the photocopy of the original letter, my lord. At the bottom of the letter, my lord, there is a handwritten note forwarded to the manager, PLR, for further action, 30th April 2015. My lord, if I receive the part payment in the year 2013, then what was the occasion to settle the matter on 2015? And who authorized the trade union? Trade union, the writ petitioner before your lordships are never represented in any forum by the trade union. If they can produce before your lordship a single paper that the trade union has been, the writ petitioner has been represented by the trade union, I'll be out of court.
Yes, anything in reply?
Lord Sahib, submitted short notes of argument, everything I stated in notes of argument. Lordship, only for recalling, Lordship, page 20 is the first day I appeared, and 13 is not the
the back wages portion. This is the wrong submission. Lordship, page 20 may be seen that I raised the point that page 20, Lordship, before Justice Amrita Sinha.
Yes.
The learned advocate appearing for the general manager Eastern Coalfield Limited submitted that petitioner has entered into settlement. Pursuant to said settlement, back wages has been released in favor of him. He pray for time for filing Lordship the same position.
Where is that settlement?
Huh?
Where is that settlement?
That letter, Lordship, by the writ petitioner.
Yeah.
Writ petitioner, I wrote letter that I am ready to accept 40%.
No,
Then we paid, not earlier paid. Back wages was not paid. Gratuity
my
was
letter
paid.
at page 25.
Lordship, back wages was not paid. Back, Lordship, when we,
You
Lordship,
say that the writ petitioner wrote a letter accepting 40%.
not 40%, 100%.
But in the subsequent resolution taken by you on the basis of that letter,
That
you
letter.
have admitted that the writ petitioner has said that he was not aware of the contents of the letter.
Yes.
Lordship,
I'm
not
grateful.
before me, not before the he raised the matter on the 26, 20,
They have relied
29,
upon in their affidavit in
29,
opposition.
Lordship, section 29
sorry.
approached the regional
In their
labor
application.
commissioner.
In their application, Malad, they have relied upon.
He raised the matter before regional labor commissioner, as per Industrial Disputes Act. There he said, I do not know the content. Not
Please,
said,
please come to your resolution,
Lord-
page 31.
Lordship, page,
It's 31.
Page 30.
Lordship,
Page 30 is your resolution.
Lordship.
Page 30, Malad.
The last paragraph.
So I'm led by Mr. So.
Page 30, Lordship,
This is your resolution.
this is the minutes of meeting.
Yes.
It was found that,
Resolution was drawn by you, isn't it?
yes, yes.
Have you seen the last paragraph?
It was found, it is found that a letter of
Last
agreement.
paragraph.
I am going. That a letter for agreement accepting 40% back wages signed by the Sukumar Ghosh, ex-employee, has been submitted to the management. On the basis of which the back wages of workmen concerned awarded CGIT has been settled. We paid 40%.
Next paragraph, please, sir.
On the investigation, the workman Sukumar Ghosh accepted that the letter of 9521 has been signed by him, but he did not know. He signed
Please, the remaining part.
but he do not know the contents. Workman also produced a copy of the another letter signed by him. This in this addressed to the Lordship. As per the his letter, 40% of was paid. Not we are Lordship page
You have
25.
taken his signature on a letter without informing him about the contents.
Lordship, I don't. If he has
That is
written,
your admission.
not admission, this is minutes of meeting, not admission. This is recorded in the minutes of meeting.
Have you disputed
They
it?
have relied upon.
Meeting.
Have you denied or disputed such submission?
No.
Yes, certainly we have said.
They have relied upon.
That's the next, the Chandi Banarji, Secretary of the Mother informed that the Sukumar Ghosh, along with wife approached him and signed the acceptance letter. Next page, Lordship. Union has raised the dispute. We accepted, not the workman, acceptance letter and requested to take up the matter with the management because we are going to file the writ petition. He knows that we are page 25 we have seen. We are going to file the writ petition, then he approached the management, not to settle the matter.
Have you denied or disputed the
Certainly,
statement of the
Lordship,
petitioner?
We have.
Where is the denial?
Lordship, the management settled Lordship, next page, Lordship. S. Mukherjee advocate informed that he had handled the cases of the workmen in the CGIT. When the award was passed, the management was interested to challenge the said award in the High Court, as there was lacuna in the award. The workman was, however, not in condition to fight the case in the High Court. Hence, he requested to take up the matter both with the management, the compromise. This is the Lordship, this is the agreement.
This is a different issue altogether. Anyway,
Lordship,
This
this
is
is
your
the, I've submitted notes of argument, Lordship, consider to what Lordship do. Because why not disclose this letter that I have approached the RLC?
That is not my letter.
reserved.
I'll
pass this.
I have
Only
submitted notes of argument.
two sentences, not as we have tried to learn. But if there has to be an agreement, it has to be between the judgment debtor and the decree holder.
Correct.
That's all.
Because if you not approach that we have.
And the union did not represent him in the
Union is
tribunal
the
level.
party in the union has raised a dispute.
Arguments.
Workman has no right to say anything.
Argument concluded, judgment reserved.
Grateful to your lordship.
Next.
Item 4.
My lord, I am appearing on behalf of the petition. I pray for time to adjournment. My lord, I have not received any instruction, my lord.
You are the petitioner.
Petitioner.
Have you served?
My lord, earlier, my junior,
You have sought time for on several
Yes, ma'am.
occasions.
only accommodated, my lord, 2 weeks adjourned, my lord, my lord.
The applicants / petitioners seek further accommodation. Paragraph has a last chance, the prayer is allowed. Paragraph, let the matter appear under the same heading on 11th September.
Yes. I'm grateful.
Item 5.
My lord, I'm appearing for the petitioner.
The alleged contempt, Lord, on the last day, I submitted that appeal is being preferred. Appeal was preferred, not your lordship. Just I will hand
Any
over the
stay?
order.
No stay, my lord, appeal has been withdrawn.
Yeah,
As
just see the
dismissed as
order
withdrawn
because
with
of
liberty
some
to file
technical
afresh.
difficulty that has been withdrawn and with liberty has been given to file afresh.
So my respectful submission, there is no stay, my lord. Last
Appeal
November,
has been
I am not
withdrawn.
getting the challan, road challan, in spite of your lordship's specific direction to issue road challan at the
Again,
earliest.
afresh, since the direction has, liberty has been given to file afresh, I have been given instruction, they are going to file afresh. I have handed over the order, not what I can.
For the temporary basis, why let them issue at least 2-3 challan. Let them prefer appeal. I have no problem. I will face the appeal. But at least let them issue from last November 2022, my lord. My total business is stopped, my lord.
You have a high expectation from the state, sir. I'm sorry.
Highest,
High expectation from the state.
my lord. That's what can I
No,
say?
I'm sorry, because I cannot do anything because as whatever I have been instructed.
By the next date, if there is no stay order, a contempt rule will be issued.
That yes,
Let me make it very
yes,
clear.
My lord.
It
A
is
bit
submitted
long
on
time
behalf
may
of the
kindly be
alleged
given.
contemnor. Yes.
Bit long time may kindly be given. I
Oh.
have been told so. I have been told so.
Then let
I'm
them
making-
issue the interim period challan. No, I have no
That
problem.
I can say it. That I can say. The authority will decide. They are going to
That
prefer an
an
appeal.
appeal preferred against the order under contempt has been withdrawn with liberty to file a fresh appeal on the same cause of action. Paragraph, on prayer of the alleged contemnor, the matter is adjourned. Paragraph, let the matter appear under the same heading on 6th September. Sufficient
6th
time, if there's
September, my
no
lord.
stay order, rule will be issued.
Grateful, my lord.
Lord, may I take back the order? Yeah.
Hmm.
Orderটা দেবেন দিদি।
Order দিয়ে দিলাম।
Grateful, my lord.
Item 6.
Yes.
দাদা appearance টা নাকি? পাঁচে।
The earlier occasion also you sought time.
They have served Apuna's report, but right now I could not find out where they have
Who
served.
is appealing for the petitioner? You for the national.
Okay,
Alliance.
Mr. Roy.
But I am appearing for, I am appearing.
On prayer of the petitioner, the matter is adjourned. Let the matter appear under the same heading on 13th September.
Item 7.
I'm appealing for the petition. Only the last occasion, lordship was pleased to direct the state respondent to file a report. But we have not been served
My lord,
any report. But the matter is, my lord, regarding, my lord, I purchased a property, landed property in the year of 2000. In the year of 2006, my lord, part of the property, it was acquisition, which I came to learn in the year of 2010.
You are asking for demarcation of the plot.
My lord. And my lord, rest of the property to be released if it is not acquired.
my
Actually,
lord, I am appearing for the state. I am led by Mr. Bandyopadhyay. In the last occasion, the state is directed to file a report in the form of affidavit. My lord, I am praying for some days to file the report because it is They have
Report is necessary.
Yes, it
Some
is
time.
because some portion has been acquired.
My lord,
Let them
which
come
I
back
came
to
to
the-
learn in the year of 2010. My lord, I was totally in dark. And till date, my lord, he had not yet been demarcated, not yet been released because,
Possession is with you.
my lord,
Possession is with you.
position, actually, how it has happened, my lord, it is adjacent to a main road. And some of the land, it was acquired, but until and unless it is demarcated, it is very difficult to find out my portion.
First you will find that page 43, the order passed by the collector. Not for.
Either, my lord, let the property be released or, my lord, acquisition price to be given.
At least a demarcation is necessary.
My lord, yes, presently demarcation is required, or if state is required to acquire
The
this.
state come back with the report because that is necessary.
My lord.
Paragraph learned counsel for the state respondents seeks extension of time
You cannot have
to
the
submit the report in the
report
form of
আছে নি?
affidavit as
Yes,
sought.
ওটাই আমাকে
Mr. Bandyopadhyay, please be ready with the report on the next occasion. It's a
Must.
simple matter of demarcation. A paragraph, let the matter appear under the same heading on
ডেটটা দেখো
6th September.
আজকে আনিয়ে নাও
Regarding acquired part, compensation has been received, no dispute.
Yes.
No dispute. But since it's portion of the entire land, there should be a mandatory demarcation.
My lord.
That's the law. Next.
Item 8.
report on the
Item number 8 and 9, both this matter, your lordship directed to file report on behalf of the state lordship. Till now, Mr. Dey is appearing. Yes, where is Mr. Dey? Mr. Dey, his junior, no one. Mr. Dey is not.
there is engaged before my lord code number 5 for the
Report was called, several extensions given. None appears for the state respondents. No report in the form of affidavit is submitted. Paragraph, let the matter appear under the same heading on 4th September.
My lord, I have
Both the matters.
my lord, this matter, my
Report,
lord.
Mr. Dey.
Yes, my lord. Today, my lord, client has come, officer has come, my lord. I pray 1 day accommodation, my lord.
Not today.
Not today, বলা হবে না। একটু
Lordship,
My lord,
both the matters 8 and 9. Lordship, except 4th September, can it be fixed? Lordship, Amlan. Learned counsel for the state respondents seeks further extension of time to submit the report in the form of affidavit. Stop, let the matter appear under the same heading on 4th September.
yes, my lord.
Can it be fixed, my lord? Can it be fixed? Yes. 5th September. 5th September, very good. 5th September, Mr. Dey. 5th September.
8 and 9 both.
9 also say, Lordship.
9,
Same.
8 and 9.
Item 10.
But I am appearing for the petitioner, my lord.
I beg to appear on behalf of the state.
Well, this is, in this matter, we have challenged a order which is at page 192 of the writ petition, by which the authorities have purported to determine the leasehold right of the demised land granted in favor of the petitioner and kindly note re-enter into formal possession of the said plot of land. Well, the relationship between the parties is governed by a deed of lease. The lease has been granted by the UD Department, Government of West Bengal. And my lord, under that lease, if your lordship kindly comes to clause 6A, which is at page 37. This is the clause, my lord, my learned friends have given a show cause notice alleging violation of this clause. To construct building in conformity with such building rules as may from time to time be framed by the government or other authority prescribed in that we have according to plan specifications or that authority within 3 years from the date of possession. Now, my lord, your lordship will see
Page 46 is my possession letter. '46 is the possession letter, which is 5th of June 1996. So I have 3 years' time. Thereafter, my lord, from page 47 onwards, your lordship will see that I have started my manufacturing activities from the said land upon construction of a factory building. Your lordship will kindly come to page 47.
Yes.
This is the registration under the central sales tax. First line says, my lord, measures precision technique, principal base of business within situate at CP 24 Sector 5 Salt Lake, is registered the dealer on the Sales Tax Act, mainly manufacturer. So kindly see, and at the bottom of page, your lordship will see high force sheet metal. That is my product. This is my registration of, your lordship will see at page 48. Factory premises is CP 14 Sector 5. This is dated 26 June 1996. So from 1996 itself, my manufacturing activity is going on from this self property. Several documents, my lord, are there, which I have annexed along to my show cause, reply to the show cause notice. Page 49 and 50 is under registration under West Bengal sales tax. 49 and 50. 50 top, your lordship will get the dealer has a factory act, plot CP 14 Sector 5. This is also dated 1997.
These impliedly suggest your construction, but
Yes.
where are your construction documents?
Yes, I'll show you, lordship. Then, my lord, page 51 is also there under the value added tax. Then, my lord, your lordship will kindly come to page 82. These are the Provident Fund annual returns. Page 82.
Yes.
Now, my lord, kindly sees thereafter. My lord, in 2009, my business was closed and I applied. There is another clause I will show your lordship in the lease deed. I applied to the government for permission of change of user. I wanted to construct a G plus 18-storied building for carrying on IT business and services. For that purpose, I have to apply for change of user under clause 9. So, my lord, I have applied and I have got a sanction plan. Your lordship will kindly come to page 87 onwards. This is the second phase of documents. Page 87, Bidhannagar municipality is giving this document, my lord. Page 89, kindly come to thereafter page 89. From the municipality, plan submitted by you along with your application dated 15 February 2006 have been sanctioned conditionally. Permission to execute the work has been granted accordingly. Let me take delivery of the sanction plan. Then, my lord, page 92. I have applied for pollution, no environmental clearance from the West Bengal Pollution Control Board. These are all post 2006. Page 92. A valuation report. Then, my lord, page 94 is my application for consent to establish. As part of this application, your lordship will kindly come to page 99, where I have given the details of the application. Kindly see at 99(6), purpose of clearance.
This is for environment clearance.
Yes, because I am now got a sanction plan for a G+18 story building.
But prior to that, there should be an application for change of user.
Yes, change of user is already there, my lord. I'm sorry, I did not show your lordship. Page 84. This is a communication from the Deputy Secretary to the Managing Director of West Bengal Electronics Industrial Development Corporation Limited. They are saying subject sending of vetting project report as furnished by Precision Technique.
Where is your application?
Yes, I'll show you, lordship. Kindly gives me a minute, my lord. My lord, that if your lordship comes to, I have the application has not been annexed, but I have referred to that in my reply to the notice issued by them.
Or the permission of change of user?
Yes.
Any of the documents?
No, that is what my case is. My application for change of user was filed before them. Application for change of user was kept pending by them. In the meantime, I have applied and obtained all these sanction plans and other permissions. This change of user has not been dealt with by them. And now they issue a show cause notice for forfeiture of the lease on the ground of violation of clause 2.6. 2.6 is the first thing where I have already constructed a factory. Manufacturing activities running therefrom.
Where are those documents of construction?
Yes.
You've shown the manufacturing activities.
Yes. I am showing your lordship, my lord.
That it was constructed within 3 years.
Yes. Reference to the above, we have been asked to submit the following: a NOC from Pollution Control Board, an authenticated consent letter from bank. In this matter, we would like to state, for one, as per memo number such and such of the West Bengal Pollution copy enclosed, no NOC is required when the build-up area is less than 20,000 square meter. Through your letter number dated 23rd November, you have confirmed acceptance of mortgage proposal. Issuance of such letter from your end is sufficient evidence that we have submitted authenticated consent letter from under we request you to grant permission for change of purpose from manufacturing of precision steel metal to IT.
This is change of purpose.
Yes.
I'm asking about the first construction.
Yes, the first construction.
Within
your
3 years of the lease.
But the first construction will definitely appear from my sales tax registration, because without a factory, I cannot have a registration. And the registration mentions the factory details. This is number one. Number two is the valuer's report. Kindly come to page 130, which is the valuer's report.
This is all subsequent, not the earlier construction.
This is the earlier construction.
This is in 2020, 2000.
No, this is
in
my lord.
2000.
Kindly see, my lord, this is the valuation. Kindly see, my lord, page 133. He is making the valuation in 22 to 2000. Of what? Of the structure which has existed. He has here.
Why are you referring to implied documents? Why? Where are the documents which show that you have obtained a building plan? The basics for construction, where are those documents?
But factory building, there is no building plan. The building factory is existing. Otherwise, my lord, kindly come to page 133.
Does the lease say so?
Yes.
Otherwise, you wouldn't have been directed to make a construction.
Valuation report and structures.
My lord, the valuation report. May I just show once the valuation report, then I'll go back to the other documents, my lord.
First of all, your lordship will see page 133.
Yes.
Year of commencement of construction and year of completion. Commenced in July 1996, completed in January 1997. Then, my lord, next page 134. B, top, my lord, part 2B, cost of construction of the storied building with boundary wall. Then your lordship will kindly come to the report at 137, which is annexure B.
Yes.
Pursuant to instruction of such and such, property has been inspected by me on 23rd February 2000, carried out survey of work executed so far up to 31st March 1997. In respect of specification, class of works, mode of execution, and also to study bills and vouchers as far as possible. Then your lordship will kindly see method adopted for valuation at page 138. Land and building method has been adopted. Then calculation of values, then this is the way the valuation has been done. Then, my lord, at page 140, certified that value of the immovable property in respect of factory building and land at premises number CP 14 Bidhannagar Salt Lake, having its registered office, is such and such. Kindly come to page 142. This is also with regard to the change of user.
Yes.
This is in 2011. Please refer to our letter dates on in regard. Maybe mentioned we had visited came to honor notice. Now, in the meantime, this 27th April 2009, they issued a notice under clause 2(6). Was sent at the above address. In this, we would like to inform, since the old factory was closed and shifted, which resulted in the subject plot lying vacant, no one was available to receive your subject notice. We are enclosing various letters and communications forwarded from time to time for vetting our proposed project report by WebL for IT and ITS service, which will speak for itself for the reason of delay. After prolonged persuasion with the authority have yielded no result, finally the authority expressed the inability to vet the project report and is intimated, which is enclosed. It may be informed the total area of a would not be more than 20,000 square meter, hence clearance of PCB is not required as per notification. We are left with the approach IT services for necessary vetting. They have vetted the subject project report expedition. We would request your authority to kindly consider our prayer for change of purpose to grant a period 3 years time to construct and complete our project. Then, my lord, after this, they issue the show cause notice in 2013. That is at page 143.
Yes.
Kindly see the allegation here is violation, show cause notice for violation of 2(6)(a) of the lease deed was served. Governor is pleased to serve a notice under clause 4 to remedy the breach clause by violation of 2(6)(a) within 6 months from the date of service and of the lease in respect of plot stand determined, and the government shall enter into possession. So this subject matter of the show cause is violation of 2(6). My show cause notice reply, my lord, your lordship will get at page 147.
Yes.
3 points I have stated. Number 1, possession of the land in the year 1996. We have installed precision sheet metal factory in the above plot with all permission. We are submitting all documentary evidence in support of existing plot land, so violation of 2(6) does not arise. Then we have said that I have decided to shift my factory to some other place, demolish the said, also decided to construct a suitable building, applied for change of purpose, and got a sanction plan on 2006. We have received no objection, no objection, airport authority permission, etc. to start the construction. Several correspondence were made, but no favorable response regarding change of purpose. So I have all the necessary permissions, but I can't start because no application, no permission for change of purpose. So, my lord, this is my reply to the show cause notice. Then, my lord, And all these documents are repeated along with this replies. Finally, kindly comes to 185, which is a hearing notice. Hearing was held on 2014 September. No order was communicated. I filed a writ petition, my lord. At page 186, I gave them a representation and recorded that, and then filed a writ petition. My lord, kindly comes to the order at page 190. Third paragraph, on a specific query from the court as to how the state dealt with the show cause and its reply, it is submitted, kindly note, that the same is still pending. The court is unable to appreciate the stand. On the other hand, when it is contended that a gross violation of deed of leave and the matter is sensitive, on the other hand, it is not deciding the show cause. The failure of the state to decide on the show cause is perplexing. In the facts, the joint secretary, being authority issuing show cause, will affirm an affidavit stating the result of the show cause. Let the affidavit be affirmed by August 10, 2021, such and such. Now, my lord, in the court, they say proceeding is pending. When they affirm the affidavit, my lord, they annex a purported order to that affidavit. And that is, my lord, page 192, which I was given liberty to challenge by virtue of a separate writ petition. Now, like, kindly comes to this order. Now, there is absolutely no application of mind to my reply to the show cause notice. Since I have stated that the factory was already constructed, manufacturing activity was going on, and thereafter there was an abandonment, change, shift of the factory, and application for change of permission per user of bid, nothing has been referred to in this order. Kindly comes, my lord, to the internal page 2.
Yes.
They have recited the facts. Thereafter, first, second, third, fourth paragraph. Lessee has failed or neglected to remedy the breach within the stipulated period. So they are coming to the conclusion of breach without reference to my documents, and they're coming to the conclusion I have failed to remedy the breach. My answer to the show cause was there was no breach. 96 possession, 97 factory constructed, manufacturing started. So a finding has to be rendered by the authority who has purportedly given me a hearing regarding my reply to the show cause. Rather, there is a presumption of breach. And they say that I have failed to remedy the breach within the stipulated period. Next paragraph, your lordship will see. It transpires from field inquiry. When was the field inquiry made? Nothing was disclosed in that supplementary affidavit filed pursuant to order of court. That at present, kindly note this, at present plot of land is lying unutilized, bounded by boundary wall with some dilapidated old structure visible inside, and lessee has violated mandatory terms and condition of the release deed. But I pause here for a moment. I have indicated in my reply to the show cause that since I have shifted my factory in 2006, nothing obviously will be visible there. And I have given documents to show that I have already got fresh permission from other statutory authorities, but I can't start the work because you have not yet given me permission for change of user.
Not considered.
So therefore, my lord, this conclusion that at present plot of land is lying unutilized is a fact which has arisen because of their breach. Had they given me the permission, my work would have started. I have paid the sanction fees. I am out of pocket. I have got all permissions, but I can't do anything on the land. And my lord, kindly note, in the show cause notice, this was not the violation alleged. Violation is 2(6). Within 3 years, whether I have started construction or not. Next, my lord, your lordship will see.
Decision was without any consideration of
In transpired from field survey after delivery of land setting up for the plot is lying unutilized. This again is my contrary to my reply to the show cause. So, my lord, my submission before your lordship is that now, therefore, after careful consideration of the matter in terms of clause 4, undersigned is directed by order of the government to determine measuring such and such for violation of 268. Not a single document which I have given along with my reply to the show cause finds place in the order. So the order, according to my respectful submission, is absolutely perverse insofar as it does not reflect consideration of any of the documents given in reply to the show cause. And the next aspect is, my lord, even if the lease deed contains a clause for re-entering of possession, does it by itself enable the government as a lessor by administrative order to enter into possession? Well, it is well settled that after determination of lease, possession has to be taken in due process of law. Due process of law may either be the general law or any special law subsisting in favor of the government. So therefore, by administrative order, even assuming this order is good, what the effect will at the most be, there will be a determination of the lease. But mere determination cannot result in eviction without due process of law. But that due process of law have not been undertaken by them.
What is this letter dated 29th November, which was issued after this show cause? You've referred to a letter issued on 29th November 2018. In prayer B.
Prayer B. Yes, thereby reporting the re-entry. Yes. My lord, this is at page 205. My lord, this is virtually, my lord, there is a notice to take possession. One copy of the action taken report of re-entering into possession and photograph of this was being enclosed herewith. So they are reporting that they have taken possession.
Has physical possession been taken?
My lord, it is lying closed, and your lordship has protected by saying that both parties shall maintain status quo.
Lying closed at the instance of the government.
Yes, but chabita kar kache ache.
So they have taken possession.
This is what it seems, my lord. Kindly come to page 205.
Yes, yes.
In reference to above memo, it is informed that the action for re-entering into possession has been completed as reported by executive engineer. So this is, my lord, what I have challenged.
Yes.
Saying that re-entry of possession in this manner is illegal and contrary to the law of the land. Because if you are a lesser, at the most a lesser, this order at the most is a notice of determination of my lease. But by giving a notice, you cannot take possession. The law of the land is, it is due process of law, my lord. There are several judgments on this, my lord. I cite only one, my lord. 1989, volume 2 SCC, page 505. This is also a case of, my lord, cancellation of lease and resumption of possession. 505. Kindly straight away comes to paragraph 30 and 31. A lessor with the best of title has no right to resume possession extrajudicially by use of force from a lessee, even after expiry or earlier termination of lease by forfeiture or otherwise. The use of expression re-entry in the lease deed does not authorize extrajudicial methods to resume possession. Under law, possession of a lessee, even after expiry or its termination, is juridical possession and forcible dispossession is prohibited. A lessee cannot be dispossessed otherwise than in due course of law. In the present case, the fact that the lessor is the state does not place it in any higher or better position. On the contrary, it is under an additional inhibition stemming from the requirement that all actions of government and governmental authorities should have a legal pedigree. In Bishan Das versus State of Punjab, this court said, we must repel the argument based on the contention that the petitioners were trespassers and could be removed by an executive order. This is what I like, an executive order. The argument is not only specious but highly dangerous by reason of its implications and impact on law and order. Before we part with this case, we feel a duty to say that executive action taken in this case by the state and its officers is destructive of the basic principle of the rule of law. Therefore, there is no question in the present case of the government thinking of appropriating to itself an extrajudicial right of re-entry. Possession can be resumed by government only in a manner known to or recognized by law. It cannot resume possession otherwise than in accordance with law. Government is accordingly prohibited from taking possession otherwise than in due course of law. So, this is the one judgment. Kindly take 2002 volume 4 FCC 134.
Yes.
Here also on the strength of the government order, possession was purported to be taken, my lord. Kindly come to paragraph 20. Paragraph 20, your lordship will kindly come. In the absence of specific statutory provision, can a person on the ground of public interest be evicted by force by the state or its executive officers without following the due course of law? In view of the ratio laid down in Bishan Das versus Maharaja Dharmender Prasad Singh, we hold that such an action of eviction by force cannot be justified in law, and for taking possession, action has to be taken in accordance with law. Your lordship will also, before that, lordship can come to paragraph 10 onwards.
Yes.
It is settled possession of law that the state or its executive officers cannot interfere with the right of others unless they can point to some specific provision of law which authorizes their acts. A constitution bench of this court in Bishan Das held that state or its executive did not have the right to take law into their own hands and remove a person by an executive order. Well, Bishan Das was quoted. Then para 11, in state of UP was Maharaja Dharmender Prasad Singh, an apprehension was raised by the learned council that if the state government on the self-assumed and self-assessed validity of its own action of cancellation of liens attempts at and succeeds in resumption of possession extrajudicially by force, it would cause great hardship and injustice. Court held possession can be resumed by the government only in a manner known to or recognized by law, and it cannot resume possession otherwise than in due course of law, and therefore prohibited the government from taking possession otherwise than by due process of law. Now, thereafter, my lords, the act, the statutory provisions of the 1980 Act were also considered. And the court came to the conclusion that you cannot take by use of force. You have to take recourse to the appropriate law. So, my lord, my submission is therefore, my lord, twofold. First of all, I am challenging this purported order, saying that the determination of the lease itself is bad because there is no application of mind to the reply to the show cause notice. And on extraneous consideration, particularly ignoring the ground taken in the notice of eviction, they have taken recourse to another instance, another ground, and purported to determine. 2.6 ground of violation of 2.6 has not been answered. There is only saying that I have failed to remedy the breach. But before that, no conclusion arrived on the documents that there is a violation, there is a breach. That is number one. Number two is, they have gone to the next part saying that we are determining because plot is lying unutilized. Reason for unutilization is contained in my reply to show cause notice. That is not considered. Plot lying unutilized is not a ground taken in the notice of eviction. So you cannot take a person by surprise in the order. These are the grounds on which I challenge the determination order. And the second part of the order, I say that it is beyond jurisdiction without any authority. They cannot, by the same order, purport to re-enter into possession only on the strength of that clause in the lease deed. They can't say clause 4 of the lease deed entitles me. To re-enter into possession, you have to take recourse to law. These are my submissions.
Yes.
And only just one thing, my lord, my application for change of permission, I have also made a prayer that should be directed to be considered in terms of the notification of the government urban development department at page 213. There is a provision specific, there is a notification and a rule specifically empowering the department to consider change of permission upon charges. So, but I am saying that I am willing to pay these necessary charges as per the notification. So my application for permission should be considered in terms of the present notification, which is in vogue.
Page 213 is the notification.
Yes. Page 213. These are my submissions.
Yes.
Yes, my lord, the right of the petitioner is only on the basis of the lease deed. And the terms and conditions.
213 read with 216. 216 is the first notification. This has been modified at 213.
The terms and conditions laid down in the said lease deed. And there is no condition or terms that the petitioner be permitted to shift his business. But he has been given the lease on the basis of the terms that he will manufacture what is the terms by establishing, constructing a factory. This was not done. My lord, kindly come my report in the form of affidavit. Report in the form of affidavit, my lord. It is very short, my lord. I am placing few paragraphs. Paragraph 2. The writ petitioner has come forward before this honorable court, praying for a direction upon the respondent number 2 rescind and or cancel and or withdraw the impugned order dated 26 September 2018 relating to the determination of the leasehold plot number such and such. The writ petitioner has also challenged the field inquiry held in the year 2009 and 2015 on the allegations that the inspection alleged to have been held behind the back of the petitioner and without any notice.
Where is this challenge in the writ petition?
My lord?
Where is this challenge in the writ petition? To the field inquiry, there is no challenge.
My lord? The inquiry, field inquiry of the year 2009 is also under challenge.
Where has the petitioner challenged the 2009 and 2015 inquiry? Where is the challenge?
Challenge.
But I think I have said
The
that
challenge?
yes,
Challenge.
I have made a, because the order refers to a field inquiry.
Yes.
This purported order, the lordship will see at page 193.
Page 30, pair H.
Whereas it transpires from field inquiry. I've said that no field inquiry was held to the knowledge of the petitioner. I'll show your lordship.
Very well, continue, please. Yes.
Then, my lord, the paragraph 3, it is stated that the plot being such and such. This is not too much important. My lord, it is paragraph 4. It is stated that the department again issued so-called notice
Round number 18.
such and such dated 27th June 2013 to remedy the breach caused for violation of clause 6A of the lease deed to the lease after long gap getting the possession of the land on 5th June 1996 in terms of the lease deed. Now, paragraph 5, it is stated that the department gave ample opportunity to the petitioner, to the lessee, to give the satisfactory reply, and also called the lessee for hearing, but the lessee failed to submit any evidence that the manufacturing unit was previously set up on the said land and there was a construction building as per lease agreement. Now the very important is paragraph 6.
Ground number 18, your lordship can keep it.
Yes. It is stated that the plot of land being plot number such and such of land leased out to Messrs such and such, the lessee has to construct building within 3 years from the date of possession of the demised land. It was revealed that the said land was vacant and the lessee has failed to submit any document regarding their claim that they have been running factory on the said plot until 2006. And thereafter the said plot of land was vacant, even assuming but not admitting, but the condition of the lease deed that there must be a construction of the building within 3 years, and the vacant land as it was found since 2009 entitled the authority to determine the lease in terms of the provisions of the lease deed. Now, my lord, kindly see the reply to the so-called, my lord, that is page 147. My learned friend has already placed it. I am placing the details, all the three. Four
The
points.
petitioner says that the construction was made in 1996 itself.
Itself and it was demolished.
That is supported by documents.
No, there are no documents.
Yes, please come to the valuation report.
Valuation report, whether the my lord, I have contended that my lord, these are the things are to be supported, that the relating to the my lord, that construct of the building, particularly my lord, the plan, sanction, document and other things. The
Please come to page 133.
my lord,
Page 133.
my lord, page 133, my lord, this is the my lord, the valuation report.
Yes.
Valuation report.
The construction commenced in July 1996. And you have not denied this.
My lord, kindly come to the my lord, reply to the 147. 147.
Yes, that also says the same thing.
Kindly see my lord, paragraph 2.
Yes.
During the existence of the factory, we have decided to shift the factory from the sector 2 to other place. Demolished the shed and also decided to construct IT building into IT building. When it was demolished, when it was constructed. And demolition, there is also For demolition, there is your permission is also necessary. They have
Clause.
clause 2, 147 clause 2.
Permission is necessary.
My lord,
Where is it stated in the lease deed that for demolition also permission is necessary? For change.
my lord, that is the corporation rules. It is the corporation rules. For demolition, permission is necessary. It is the corporation rules. During the existence of the factory, we have decided to shift our factory from sector 5 to some other place and demolish the shed.
And demolish the same man?
Demolish the shed. That is your answer. That is your and also decided to construct a suitable building.
How is this violation of the deed?
Well, lease the construction is to be made and unless and until he got the permission of shifting of his business from others, he cannot demolish the building, and he must have the construction of the building within 3 years. That building must be existed. Unless it is existed, within 3 years, construction is to be made and it is to be existed. And it is to be ratified.
Where is that stated in your lease deed, sir? Please show me.
My lord?
The lease deed says construction within 3 years.
Construction, but
And the construction was.
construction in accordance with law. Construction in accordance with law, that means with the permission and other things are there.
No construction was made.
Their case.
How is it violation of clause 26A? Please show me.
My lord?
How is there violation of clause 26A?
Clause 6, there is no construction at the time of inspection.
The documents, all the documents say that there was a. construction.
Document, my lord, if the physically there is no construction is there. On inquiry, if it is found there is no construction.
When was the inquiry held?
My lord?
When was the inquiry held?
The inquiry was made several times in from 2006 and 2009.
The documents say that there was a construction in 1996. Within 3 years, there was a construction which may have been demolished subsequently.
But
But
that is the violation. Demolition cannot be made. Demolition cannot be made without permission. And if the construction is not there, well, the construction means that does not mean that I will construct one day and I will demolish it and the construction has complied. Construction means it will remain construction, it will run factory unless and until the other thing is being permitted, unless he has been given the permission that you will shift your business, you will run another business.
Has applied for change of user.
The application does not mean that he has been given permission.
That's all your submission?
And my lord, I am again repeating, my lord, the impugned order, page 193.
Yes.
193.
Before you proceed further, may I request you to come back with these documents of the initial construction?
Yes.
And the demolition?
My lord,
There is probably with regard to demolition, there will be no document.
But can you demolish on your own?
It is not
Without
a case of,
permission.
it is not fully demolished. As your lordship will see from their own order, the order records that there are sheds and structures still lying. It is abandoned.
Page 1.
I have shifted my factory.
I have stated demolition in your reply.
Well, demolition is not fully demolished like that. Well, your lordship will see the order. The order says itself says.
Page 193.
Yes, 193.
Whereas it, middle portion, whereas it transpired from the field inquiry that
Dilapidated old structures are there.
Yes, visible inside. And only one thing.
The condition is the structure, not the old structure or dilapidated structure.
Dilapidated structure is also structure.
But
My
I
lord,
see the
my lord,
notice once.
the,
show
for
cause
running the factory, that lease has been given to run the factory, not to by way of constructing something. This is the government land. It has been given so that the factory is being run for the purpose of that, so that my lord, the business is running, some employees are being provided, everything is not that these government lands are being given
Employees are provided those documents.
by the petitioner, but it is public purpose. This is for public purpose.
my factory was running, that is evident from the sales tax registration.
Well, my lord, his factory is running, my lord, so, up to which date?
No, that is what I want to come. Kindly come to the show cause notice once. At page 128, the first notice,
Yes.
third paragraph. In terms of clause 26A of the aforesaid indenture, lessee company was required to construct building as per building rules within 3 years from the date of
It's not
taking over
building
the tax
rules.
again. Such extended time as may be allowed by the government in writing, failing which the government reserves the right to resume plot. And whereas, kindly note the allegation, company has failed to construct building on the said plot of land as yet. I am supposed to meet this allegation.
Yes.
Did I or did I not construct building within 3 years? I have shown documents from 1997. My factory was registered and I was giving returns under central sales tax, West Bengal sales tax, everything. And
Why don't you come back with the construction? documents?
My lord, page
that I
one,
will, that I can.
my lord, page
The
128, my lord, the first show-cause notice, it has been specifically, my
But
lord,
now they
stated that
can't change my ground. They can't now say I am resuming
as
determining
per
the lease because
building
it is lying
rules
unutilized.
and the
That is
company has
not the
failed.
violation you have complained of.
My lord, page 128,
Yes.
as per building rules and
Where is your
petitioner,
case that it was not as per building rules?
Since,
my lord,
no, no,
your-
that's the.
my lord, petitioner,
Their case
my lord,
is that there
the,
is
my
no
lord,
construction.
my lord, kindly
And this is no
see the next
construction
paragraph.
as yet.
So why don't you?
No,
come
no,
with
no,
the
no.
Construction documents.
My lord, I'll try, my lord,
The
your lordship.
sanction plan, the building rules, that should be there.
Yes.
I shall try, but your lordship will see. Breach is, there is no construction as yet. Within 3 years, I was supposed to make construction. I have not made construction within 6 years.
That is what I said at the outset, that impliedly it shows that there was some construction in order to run a factory. But there should be direct documents.
Yes, valid document as per rules.
I will.
Please come back with.
I
the-
will, but kindly,
documents of
I would like to
construction,
make
that's all.
only also one additional submission on the next day. That when an authority passes an order and that order is tested by way of judicial review, that order will have to stand or fall on the grounds contained in that order. Today, my learned friend, by way of supplementary report or otherwise, cannot supplement the grounds or reasons.
No, 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 no.
That is one.
No, my lord,
And the show cause notice
yes,
contains an
yes,
allegation
my lord,
of 26A.
no, Lord, it is our notice. We
Order
have
has
said
to
this.
Order has to be passed on the strength of violation of
Yes,
26A,
yes.
not that the plot is lying unutilized.
Yes, my lord,
cannot
that
be
is,
a
that
ground
is
of buying.
26 violation, the show-cause notice is only on the violation.
Says there no construction, it's a vacant land, lying unutilized.
They are saying.
That
You
is
are-
the show cause.
Yes, my lord, kindly see, as per building rules. If it is not as per building rules,
No,
that
now you are
it should be
changing.
deemed.
That is not your case. That not is your case that you have
Yes.
constructed an illegal building.
My lord, kindly.
Your case is, see, company
My
has
lord,
failed.
my case, my lord, my
At all.
learned friend will not
At all.
establish my case. My lord, kindly see page 128.
I've seen that. Yes.
In terms of clause 26A, the aforesaid indenture of the lease, the company was required to construct building as per building rules. This is my case. This is my case. I am not a-
Continuously has to be as per building. rules.
Building rules.
Construction
And
has-
company has failed to construct building on the said plot as yet. This is the my lord, second ground.
So building rules is not the issue, sir. The issue is no construction was made. That is your allegation.
My lord, any construction, that should be admitted. Any construction cannot be said to be a construction.
The lease doesn't permit an illegal unauthorized.
In accordance with law, lease says in accordance, lease says in accordance with law.
Yes,
Yes, lease said in accordance with law.
writing a supplementary affidavit to produce these documents
My lord,
of the initial construction.
my lord.
Let the matter appear for orders because I've heard the matter.
Yes,
I only need the documents.
If at all I have, my lord, I will file.
Otherwise, sir, the case becomes difficult.
But I will argue, my lord, because this is these documents are not considered at all. They have to made out a case that my documents which I filed with the Central Sales Tax Authority and their department
The
are
authority
all
says-
concocted
The
documents.
authority says there is no construction. So you have to show the construction.
That is one. But the authority, my lord, the authority while dealing with my reply to the show cause notice has not disputed any of the documents. These documents are statutory documents. I have filed a return. I have been assessed to financial liability on the basis of those documents. So they have to say that that is a serious allegation, which they have not made.
At the same time, what is your difficulty in coming back with the documents?
I,
of construction?
if I have, obviously I will come. I will not. But question is, these are all very old documents. I do not know whether I can get the sanction plan of 1997 or 1996. The lordship will keep it. I will take instructions. If it is there, I will definitely file a supplementary affidavit.
Be there, yes.
Otherwise, my lord, I will have to argue on the other documents which I have.
No,
And-
they're admittedly not under challenge. The other documents are.
That
not
is what
been,
I'm saying. If that is not under challenge, is it now open to say or justify this order which does not reflect consideration of those documents?
Let it appear as for orders, please.
Yes,
come back with the-
kindly.
Third learned
Well, the
counsel
kindly
for the
extend the
parties.
interim order which is subsisting in
yes.
the matter.
Interim
It is till 31st of August.
31st of August. Yes. Can you come back within the set date, within 31st of August? Or you need some more time?
2 weeks, kindly give. 2
More
weeks.
time.
2 weeks.
Third learned counsels for the parties.
Interim order টা বলে নাও 15
Learned counsel
September.
for the petitioner seeks to use a supplementary affidavit annexing relevant documents pertaining to construction of the building. In terms of the paragraph, let the matter appear under the same heading on
We have to say that we are seeking the court.
12th September.
Right.
12th September,
My lord.
Come and say.
under the heading for orders.
Interim order till
Heading for orders on 12th September.
My lord, interim order till 15 September.
Slightly more, my lord.
I have 30th September.
30th September.
Paragraph, the interim order granted earlier is extended till 30th September or until further orders, comma, whichever is earlier.
Deeply obliged, my lord.
Well, I am taking the leave, but I really don't know whether I will be able to file.
Fine.
I will.
Item 11.
Please, your lordship, my lord, I have an application, my lord, for addition of party in this matter, my lord. It is not appearing in the list today. It was there, my lord, on the last occasion.
Can 1 of 2023?
Yes, my lord.
I am for the writ petition.
Yes, have you received
I
the
was
copy?
directed to.
My lord, they have served me a copy of application, but the application is not in list. Let that can be listed, but they have filed a report.
I filed it.
This test,
It's 1 of 2023.
Yes,
is the
ma'am.
application. Yes.
Oh, my lord, I have filed my report.
My lord,
of this one.
the
I
state,
was directed to file the report.
my lord, your lordship may kindly take the order 30th January.
Application. Do you have a spare copy of it?
Application? Yes, yes.
Yes, sir. Oh, it's,
My lord, have a look at the prayers made, my lord, by the writ petitioner, which your lordship will find, my lord, at page 9. It's a weird writ petition, my lord. These are valuable properties, my lord, in Topshia. Kindly have a look at the prayer A. A writ in the nature of mandamus directing the respondent authorities, particularly such and such, South 24 Parganas and District Registrar South 24 to immediately and to disclose and to provide necessary information and or documents relating to the concerned general diaries lodged with dated such and such, being annexed to P5 to the instant writ application and to provide necessary documents. Certified copy and or documents with regard to the execution and registration of the deed of the petitioner duly recorded as deed dated 24/5/59. This is the deed, my lord, he is referring to. But duly registered in book number 1, volume number 12, pages 206 to 208. And kindly turns over, my lord, to prayer C. He wants mutation after that. My lord, I am showing before your lordship, my lord, these properties, this 1959 deed is a subject matter of suit, and this property, my lord, belongs to me. And he's praying for mutation. So I need to be heard, my lord. This is why this application has been filed. My lord, I have annexed documents to show, my lord, that the properties I have, my lord, purchased.
Copy
And this 1959 deed and a subsequent gift deed which he is relying upon are all forged.
Not only that, if it's a prayer for mutation, how will this court have
I
jurisdiction?
bow down, my lord. I bow down.
May I just?
So that's why kindly adds me a party, my lord. Kindly directs my learned friend to give me a copy, my lord. I'll come back, my lord, and oppose the application. Because whatever, even if your lordship is inclined in some way, I don't know, my lord, my rights are affected here in a big way.
Before your application is considered.
My lord, just now I got copy. They say, my lord,
I'm not considering the application.
My
Now.
lord.
How does this court have jurisdiction? Mutation is under the.
no,
Land
if your
Records Act.
lordship, my lord, may I place it? Kindly look to the order passed by your lordship on 30th January 2023. Kindly look to the order which your lordship entertained and passed.
I got the
On 30th
দেবো
January.
সবই দিয়ে দেবো দেবো না কেন মানে আমার প্রপার্টি নয় তো প্রপার্টিটাও তো দিয়ে দেবো মানে আমার তো কিছুই নয় ভাই
সেটা ঠিক কথা।
তাহলে
I agree.
আমি কিচ্ছু রাখবো না
I agree.
kindly look to the order. The second paragraph your lordship will find it is submitted on behalf of the petitioner that an application for the petitioner before ADSR records being fifth respondent herein for certified copy has been informed that the deed has been misplaced and general diaries were lost 2 times on 8 January 2013 and 25th March 2019. The council was directed for appearing for state to file a report. Now, my lord, these are the 2 diaries informed in annexed with the writ application. Now, with this cause of action, I approach and the state was directed to file a report.
You have another cause of action.
Yes, I will come to that. Yes, I will come to that, my lord, to that extent. A prayer on that date, an objection was raised that this would be considered later on, whether this can be decided here or not. But for right now, I am not going on to that because pursuant to this direction, it was subsequently extended. A report has been filed by the state now. My lord, a copy has been given to your lordship. Kindly take the report. হ্যাঁ আমাকে কপি দিয়েছে মাত্র
Say that.
Firstly, my lord, yes, I have. No, no,
If you are still pressing prayer C, this court will not take the matter.
my lord, your lordship will determine that. For the time being,
So it's scope for this court to determine it.
my lord, that your lordship will decide. For the time being, I pray, my lord, the report which have been filed by the state and a copy is given to me, I will file exception to this report. That is one part.
Then prior to that, the application has to be taken up for
My
consideration.
lord, I take up. Yes, I am not on that. I am not stopping. Simultaneously, both can go. I will not pay for any order unless his application is heard. Undoubtedly, I do not pay. My lord, I got a copy just now. I will try to look into, and he says that he has title. Obviously, if he has a title, my lord, he will be a party. But I need to take instruction and file an objection. Yes, just now they have given me a copy. I will file an objection to his addition of party, an objection against the report. Your lordship will take up addition of party first.
The report,
No
my lord,
matter.
kindly considers the report after, my lord, I am added so that
Let addition be taken up first. Objection.
I have got.
Yes, I can file objection. Your
I have
lordship
a
will
copy
take
of
up.
the writ petition and the report, so I can also, my lord, come.
Yes,
ready with the.
obviously, my lord. When he has filed, it's my duty to give him a copy. So
My
that,
learned friend is agreeable, my lord.
so that
Even it is allowed.
it's not question of agreeable, my lord.
Learned
If
friend is
it's his property and he finds that it's not yours,
But I'll tell your lordship.
I must.
This 1959 deed, your lordship will find, my lord, from the report of the RTI, doesn't belong to him. It is somebody else's. I do not know whether the state has given that report before your lordship or not. That's a forged deed. A person per se on the record is, my lord, coming before your lordship with a forged document.
But
Per
see-
se. I'll show that, my lord, from my application. itself.
আমাকে একটু দেখে নি additionটা. Of course, sir. you will see.
Because I don't know, my lord, if
My lord-
that's there in the report itself right now.
He will also get a time after being implemented. I am not insisting for any interim order of any nature, once he claims it. But since it is a valuable property, Mr. Chatterjee is here. The law is somewhat different, my lord, in respect of valuable property.
Valuable property, the law different হয়.
Yeah.
Learned counsel for the petition.
Mr. Gupta can say anything he wants.
Valuable property though.
File an objection.
Fees-টা different হতে পারে। Fees-টা different।
বলছে fees-টা
Application
different.
being stand 1 of 2023 and an exception to the report submitted on behalf of the state respondents. The current affidavit of service are report in the form of affidavit submitted on behalf of the state respondents is taken on record.
Within 2 weeks, I will file objection.
Intending to file
না, না।
kindly.
হ্যাঁ হ্যাঁ সবই অ্যাডভান্স দেবো
Exception to my report.
সবই অ্যাডভান্স দেবো না দিলে হিয়ারিং নেবো না ইন্টারিম অর্ডারও চাইছি না
ভালো ছিল তো।
Matter
তো
appears-
কেন চাইবো আপনাকে
অত ভালো ছিল নয় দাদা, কিছু একটা ব্যাপার আছে।
ভ্যালুয়েবল প্রপার্টি বলে
1st September.
my lord 2 weeks to file my lord objection in respect of both 2 weeks addition of party না কতদিন দিয়ে
6th September.
grateful
Lord, we'll use a reply. They will use an opposition to our application.
কি বলছিস
Yes.
Then I'll use a reply to that.
না টাইমটা কভার এসে যাবে 2 weeks
Please serve an advance copy so that we
হ্যাঁ
can deal
না
with the
না
matter
না
of the
2
next
weeks
day.
হওয়ার পর
হ্যাঁ, 6 September.
grateful ঠিক আছে
If you
grateful.
are consenting to it, then.
No,
you
no,
need
grateful.
an opposition.
no my lord I will check up
Please check.
I do not
Please
know
check.
my lord.
He will not consent. He will not, my lord, oppose
Sir,
after.
kindly consider the difficulty because it is valuable property. I have to take instruction from client.
Yes,
I
please.
cannot, my lord, say of my
Then
own.
fight it out on merits.
I,
and allow him to
I must
participate.
take instruction whether their deed has been executed or.
There are previous suits which he suppressed. There are previous orders which he suppressed. He has filed an RTI, my lord, before Hooghly for a property, my lord, which is in Alipur.
Lord, if I have suppressed, I will not be getting any order.
everything,
But I
my
do
lord,
not know what I have, sir. I must take up
Doesn't
what
know
he
what
has
he has
tried to
He doesn't know.
bring
my
it
lord.
to the court. I do not know what his client has suppressed. That I also
That is
do
the
not
second
know.
suppression. Let him come.
I will check.
Next.
Item 12. My lord, item 12 appearing on behalf of the petitioner, my lord.
Yes. Respondents.
Lord, served upon all, my lord. My lord, I am for the state respondent. My lord, this is the, my lord, difficulty is that, my lord, initially the matter is to the Mr. Miss Choma Mukherjee and me. My
Yes.
lord, I think, my lord, Miss Choma Mukherjee is no more in the panel.
Where is your affidavit of service?
My lord,
There are
this is
several private respondents.
Yes, my lord. This is the.
You are appearing, so that's okay. I'll record your name today. Served all the private respondents?
Yes, my lord. Difficulty is that, my lord, there is a report be needed. And I don't know if the report is given to Miss Mukherjee or not. My lord. I have served 2 times upon the private respondent, my lord.
And they are not, it's not served.
My lord, kindly see the after 20, page number 20, after 20.
All served?
Yes, my lord. My lord, matter relates to the demolition of unauthorized construction. 62 Act will be applicable, my lord. I given the representation to the concerned authority, page number 29, my lord.
Government land adjoining your property.
My lord.
Government land adjoining your
Yes,
property.
yes, my lord.
How are you affected?
1,
Page?
page 29.
The representation be considered.
My lord.
You don't need further instructions on this.
Respondent number 3 is the appropriate authority.
Yes, there is due. Affidavit of service. None appears for the private respondents, despite service. Paragraph. The petitioner. The petitioner claims to be the recorded owner of the plot in question and complains that the private respondents have raised unauthorized construction by encroaching upon a portion of government land adjoining his plot, thereby obstructing his egress and ingress. Stop. The petitioner submitted a representation before the concerned authority in this regard on 11th October 2022. It is yet to be considered. Stop. The petitioner prays for a direction upon the authority to consider the representation at the earliest. Paragraph. It is submitted on behalf of the state respondents that the third respondent to consider the representation in accordance with law. Paragraph. In view of the above, the petition is disposed of, directing the third respondent to consider and dispose of the representation submitted by the petitioner dated such and such within 3 months from the date of communication of this order, upon affording reasonable opportunity of hearing to all the interested persons, including the petitioner and the private respondents, in accordance with law. Disposed of, Richard. Disposed, Rajiv.
Grateful.
Okay.
My lord, I am for the petitioner, my lord.
Yes.
In this case, my lord, some properties, I have stated, my lord, paragraph number 2.
Who is appearing for 4 and 5? You are the
I am service early allocation, all the service is complete, my lord. And the state respondent, all the. My lord, the records still now is recorded in the LR.
Respondent numbers 4 and 5.
My lord, I am appearing for ADDA.
4 and 5.
4 and
4 and 5.
4 and 5.
Yes. Mr. Bandyopadhyay, you are appearing for the state.
My lord,
Yes.
still now is recorded in LR in the name of the predecessor of the petitioner number 1 and the petitioner number 2 is the Borgata. And also in RS record, recorded is the name of the same. But there is no requisition or acquisition as that not aware of the petitioner or petitioner number 2. But
yes.
Respondent number ADDA authority, being the respondent authority, is demanding that the land has been acquired and subsequently transferred to the concerned ADDA for development or any purpose. But still now that Khotian number is recorded and till now the record is shows that the owner of the land is the predecessor of the petitioners, my lord. That is the kindly see, my lord. Annexer P1, my lord. The record, current land record. That is Atul Chandra case, Satish Chandra case, and Bhushan Chandra case. But my question is that if the land has been requisitioned or acquired, there is that acquisition notice or there is proceeding, but there is no proceeding and there is no, but and after that RTI application before the concerned LA department, but LA department did not answer the same that there is no LA acquisition case or not. My lord, kindly see annex page, my lord, page. Kindly see. Page 44, my lord. Last answer from the Department of the District Magistrate and Collector Land Acquisition that they have not find out any LA case regarding such plot. But ADDA concern still now they claim that the land has been acquired and developed and the authority is the under the ADDA of the concern. It is the my question is that is my prayer is that if the land is acquired, that is must be due process of law, but there is no any process or any notice or any other proceeding about the land acquisition.
Let's hear the state.
My lord, kindly report call for from the.
Let us hear the state.
My lord.
Well, it appears from the page 48. Possession has been handed over.
Who hand?
Read petition.
Without acquisition?
That is the after RTI acquisition.
It is not acquired the possession, how it will be handed over to the IDDA?
My lord, the petitioner is also not sure whether it is acquired or
No,
not.
no.
This is only for fishing out evidence. Lordship takes up page.
Knowledge of acquisition.
Well, takes page number
is
14
no-
first. He only wants the details of the acquisition, information, which has been already been provided to
No,
him.
it is the authority by the Durgapur Asansol.
No, he says whether it was acquired or not.
If acquired, then it will be done or it will not be done.
Yes, that is what kindly
No,
see
that
call for
cannot be.
report, my lord.
Either or
Petitioner
not.
says that the ADDA is trying to take away the property, though it has not been
ADDA
acquired.
has taken possession, my lord, page 48, your lordship. See,
Kindly
Lord, page number
who take possession?
Page number 52 is our reply to the RTI, and from page number
It is the
48
RTI
onwards,
document.
the documents have been produced.
As per 47 earlier,
Let him
some,
complete, please, let him complete.
yes.
Page number 52 is the reply. It's a letter that begins, my lord. Page number 52, it's not arranged properly.
52 says ADDA has full and valid title. How?
My lord, I'm submitting. He was asked to deposit the amount and so that the documents can be furnished. Now, lordship kindly takes up page number 48 onwards. It's not properly arranged in the writ petition. Page number 48, my lord. At the base, my lord, it is stamped documents released under RTI from ADDA at the base of
It is the possession, certificate of possession.
my lord. And 49, my lord, it's the plan.
Yes, but the basis of these documents.
But I'm not on that. I am that
Thing is, it has to be acquired.
his claim is not against the acquisition. His claim is for information. He says that he has applied for RTI, under RTI has not got information.
But he has got information which says that the LKS number is not there. He wants to know whether the land has been acquired at all.
There is a provision for appeal under the RTI Act.
No RTI question.
That at all. He has received a reply of the RTI, which says that since the LKS number has not been provided, he was not given the
Kindly see
information.
prayer, A.
He does not challenge the acquisition.
A read in
He is
the
not aware of the acquisition at all.
Yes.
Please show me that the land has been acquired in terms.
land acquired, my lord, I'm showing,
Yes.
my lord, your lordship. Kindly
Has to
see
be
his prayer,
documents.
whether read petition is maintainable in this court or not. A read in the nature of mandamus and or any other appropriate read or reads orders, direction or directions commanding the respondent, or particularly the respondent number 3, to disclose the land in question situated in Paschim Bardhaman under Durgapur New Town Police Station, such and such, corresponding and measuring whether it is acquired or not.
Yes, he doesn't.
He
know.
sought for information to the respondent number 3. If it is violated, to disclose the information. He sought for information. If it is not sought, whether the information is not supplied to them, he may prefer an appeal before the appellate authority.
Information was supplied. He is not on that at all.
Well, that
He is
information
not
was.
sure whether his land is acquired or not. He is claiming if it is acquired,
The fact
then not
that
to
the-
disturb the peaceful possession.
There are two RTI
What ADDA?
applications. One is before the ADDA. We have supplied the information. He's not on that. He is aggrieved against he says that information has been not supplied by the collector. That is where his grievance lies.
No. His primary grievance is you are trying to utilize the property,
Yes.
though he doesn't know whether it has been acquired.
Well, where kindly takes up the prayer. He prays it against the respondent number 3.
Not to disturb peaceful possession of the petitioners over the land in question.
No, that's the interim order, but the prime
Why interim order?
my lord, authorities, particularly respondent number 3, to disclose the land in question.
The last part?
I know.
The report.
And not to disturb peaceful possession. If the main prayer does not remain, my lord, the corollary does not also remain.
The application is frivolous. It should be.
He said the acquiring authority must grant him information.
The entire plot was acquired.
My lord.
In acquiring 1959, they says. 6 and 6, you also.
But
Really in apprehension. in a distribution.
নামটা লিখেছিস? হ্যাঁ। My
Yes.
lord, my first question, I have to first know that whether the land acquired or not. And my lord, if the land is acquired, has been acquired in 19, they are stated than 1959, still now the record shows that the owner of the land.
Correction of records, that's a
But
different issue.
when the land requisition or acquisition,
Challenging that is in another forum.
my lord, then record must be the Khotian number 1. Must be Khotian number 1, that is the vested land.
There has not been a correction of records, sir. That's technical, isn't it?
Still
If
RS.
these are the documents of acquisition, you have a separate cause of action, you can ask for compensation.
Yes, compensation. Then I have to file next.
That is a separate cause of action.
Yes.
So in this writ petition, there is nothing further remains in this petition, isn't it? So let this be disposed of.
Yes, disposed of that, they admit that the land has been acquired, but with due process or without due process, that is the next question. Yes,
That's a
right.
separate cause.
That, yes, I have give the answer, my lord, got the answer, that is.
Report submitted by the state respondents is taken out. Primary grievance of the petitioners is that the Durgapur Development Authority
আপাতত স্ক্যান করে নিয়ে নিচ্ছি আমি, আগে দিয়ে দিন, এখনই দিয়ে
is disturbing the peaceful possession of the petitioners in the plot in question
একবার ব্রিফের গাদায় ঢুকে গেলে তখন মুশকিল।
on the plea that they have been given possession of the plot by the state government upon acquiring the same. Stop. Paragraph, learned counsel for the petitioners submits that the plots in question, are recorded in the name of the predecessor in interest of the first petitioner
Petitioner number 1.
and no notice of acquisition was to the requiring body a government order dated 14th September 1959. Stop. Paragraph, in view of the above, comma, the petitioners seek to take necessary steps for payment of compensation and the like, in a separate proceeding. Paragraph, nothing further remains to be adjudicated in the present writ petition, and as such, comma, the same is disposed of. Urgent certified process.
My lord. নামটা দিচ্ছিস?
14. I'm for the petitioner, my lord.
I am for the respondent number 9, my lord. But I think this writ petition has become infructuous.
My lord,
Because on the basis,
service.
although there was no leave to file affidavit in opposition,
Who is appealing for the state?
My lord,
State?
already I served the copy to all the respondent. This is the evidence.
on the basis of the representation of the petitioner, an inquiry was conducted and the eviction notice was issued upon the respondent. So subsequent to that, after the receipt of that eviction notice, we preferred a writ petition before this honorable court. Well, this is.
It was not called for, sir. The
My lord.
affidavit was not called for. I will not
My lord,
accept
I
it.
have, but my lord, can we go through I was only referring to the document, the order passed by this.
Submission.
My lord,
My
this
lord,
honorable
in
court,
this matter, I am the poor cultivator.
Give me a minute, please. Where it is, sir?
And
Sir,
kindly
please.
see the paragraph 6 and 7.
Anyone for the state here? Mr. Bandhu.
Already, my lord. SD also submitted one order.
It is there. He is not there. He's there.
against that,
I did not see Mr.
my lord, against that eviction notice, my lord, a writ petition was filed. My lord, Justice Sen,
Serve a copy to Mr. Dey.
my lord.
Petitioner.
এটা হচ্ছে আমার opposition-এর,
Not that copy, the repetition.
my lord, petitioner.
But at this moment, I have no extra copy.
তুমি পড়ো তাহলে, তুমি বলো পরে।
My lord, kindly see paragraph number 6.
এটা আমার
That the petitioner state all on a sudden, once Sri Govindo Jana, respondent number 9, herein called as the private respondent, encroached the said public road as well as my landed property and constructed a building illegally and forcefully, and your petitioner was not in a position to enter into the said land due to the said illegal construction, building, encroach, obstruction, blockage the said private respondent blocked the front portion of the petitioner's land in question. That the petitioner state that your petitioner raised an objection and request to the said private respondent to remove the illegal unauthorized construction from the front side of the petitioner's land and allow him to ingress and egress to the said land in question smoothly, but the said private respondent refused the same and creating a serious breach of peace and also threatened for dire consequences to the petitioner. Moreover, the said private respondent constructed the construction without prior permission from the concerned department, Panchayat.
Disposed of. 10-3 has been issued.
Is
This is an order under 10-3.
subdivisional officer issued this order?
10-3 order.
yes, my lord.
Yes, my lord.
Yes.
My lord, he must file appeal against that order. My lord, appeal is
So
paid.
what further remains in the writ petition?
But authority concerned not taking any action, my lord. Therefore, I come before the Honorable High Court.
Your prayer is for consideration of the representation. That has been considered.
But illegally
Section 10 proceeding.
encroached the government land as well as my land.
Your land, this court will not deal with. Only the government land will be dealt with by this court.
No, my lord.
Private land.
Also encroach my land.
Can,
I have 8 decimal of land.
can this court deal with your private land? Encroachment on your private land?
No, my lord.
Yes. Only the government land will be dealt with. Pursuant to your representation, section 10 proceeding has been concluded.
Yes, my lord.
So what further remains in the writ petition?
But the authority concerned not taking any action till date.
That is a different cause of action altogether.
Therefore, my lord, kindly consider the matter
Consider which
in
matter?
accordance with law, according to this order.
Appeal before the authority, my lord.
Private respondent may prefer.
My lord,
Private
we have
respondent
preferred
can
an
also
appeal.
file.
Eviction notice was issued, but we preferred a writ petition before this honorable court. This honorable court, my lord, this is the order. If my lord,
Writ petition.
writ- page
Not an
30.
appeal.
No, my lord, against that eviction notice. My lord, it is at page 30.
This honorable court given me liberty to file the appeal within 15 days and in them till dispose. And the respondent authorities were directed not to give any effect to the impugned notice till disposal of the appeal. Well, that is at the penultimate portion is at page 32. And our appeal is at page 34.
There's an order of this court not to give effect to this order till disposal of the appeal. In this writ petition, nothing further remains. This is not necessary. I'll record your submission.
Well, should I give the order only? Take out the order and give it
Which
to
order? Nothing
the
is
order.
necessary.
My lord.
I'll record your submission.
Copy the petitioner copy.
Heard learned counsel, affidavit of service given. None appears for the state respondents despite service. Mr. Dey, who is present in court, service appointment regularized court, copy service direction. Paragraph.
Opposition. এটা কেন এটা দিলাম যেটা
Petitioner
হ্যাঁ
এটা তো আপনি দিলেন আমাকে।
হ্যাঁ নিল না তো
raised for a direction upon the concerned authority to consider his representation submitted on 11th October 2022, complaining unauthorized construction made by the private respondent
কপি এখানে অ্যানেক্স করেছে
by encroaching upon
ওখানে অ্যানেক্স করেছে
PWD road adjoining his property, comma, thereby obstructing his egress and ingress. Stop. Paragraph. It is submitted on behalf of the petitioner as well as the private respondent that during pendency of the writ petition, comma,
পিটিশনের কপি লাগবে না?
that pendency of that pursuant to the representation submitted by the petitioner, comma, proceeding under section 10 of the West Bengal Highways Act 1964 was initiated and order has been passed under section 10(3) of the Act by the subdivisional magistrate, comma, AGRA on 12th April 2023. Paragraph. Learned counsel for the private respondents submits that the private respondent has carried the said order in appeal under section 10(4) of the Act and by an order passed by a coordinate bench of this court on
My lord, that is on 28th of April 2023.
on 28th April 2023 in WP
10225 of 2023.
2022.
23.
2023, comma. The please show me the order once, sir.
My lord, direct to hard copy.
Copy of what?
This application.
You'll receive copy of the appeal.
Yes, ma'am. I have not received appeal.
The concerned authorities have been directed not to give effect to the order dated 12th April 2023
In eviction case number 2559 of 2023. That is at the first paragraph. Page 30.
till the appeal is taken up for hearing. Paragraph in view of the above, comma, nothing further remains to be adjudicated in the present writ petition, and as such, comma, the same is disposed of. Paragraph urgent certified website. Therapy.
My lord, give me liberty to hand over fresh copy.
Which copy?
This copy of,
Appeal has been preferred, you'll get a notice of.
but I have not received anything.
He's a party.
It's a party.
My lord, there he is a party.
In the appeal, he
My
should be a party, yes. You receive notice in due time.
But receive the notice in due.
Till date, I have not received any copy.
That cannot be dealt with in this petition, sir.
Yes.
Next.
15.
Well, I am for the petitioner. Last 12th of July, your lordship was pleased to hear the matter, my lord. On that date, my lord, the prayer was made for adjournment on the ground on behalf of the state respondents. My lord, this is second time or third time before lordship I am moving the matter, my lord. Your lordship was pleased to pass.
My lord, I am for the state. My lord, Ansar Mondal, he is for the state. He could not come today due to his illness. My lord, his leg was broken.
That has happened before a very long time. He can appear virtually, isn't it? Or please appoint someone else to take care of the matters.
My lord, we could not
For
get
about
any
3 months, 2 months.
almost 2 months.
So he has the opportunity to appear virtually.
He is advised to take bed. He is actually advised to take rest. And because the leg is actually plastered, he cannot move. That's why, your
So
lordship.
the matters cannot, I'm really sorry for that, but matters cannot wait eternally.
Your lordship, even we haven't got the report, your lordship. If your lordship can kindly grant us 1 or 2 weeks time, we'll manage it, or we'll ask Mr. Mandal to appear online.
Order of your lordship has not been complied with. That's my grievance, man. He is challenging your lordship by showing Supreme Court judgment. They could have preferred an appeal, challenging your lordship with the appeal court. Can the officer, the AGM, being an IS officer, can say that your lordship's order is bad because of the Supreme Court judgment? Can he say so?
Let them come back. Then
My lord.
they'll take a position.
Well, this is too much.
Next day, please be prepared with the matter.
Yes, your
And no report was called for. Why are you talking about a report?
Well, your lordship, we have not any instruction. So what will I submit, your lordship?
On prayer of the state respondents, the matter is adjourned. Paragraph, let the matter appear under the same heading on 12th September. Let it be till now.
State.
Mr. Mandal is appearing for the state, your lordship. I'm
Petitioner, my lord.
filing.
Report has been given.
I'm
but
filing
no
the report in
exception
form of
has been
affidavit, your
given.
lordship.
You want to use an exception to this? Very good. Report in the form of affidavit submitted on behalf of the state respondents is taken on record. Paragraph, learned counsel for the petitioner seeks to use an exception to the report. The paragraph, let the matter appear under the same heading on 14th September.
Your lordship, I am for the petitioner, your lordship. I have purchased on land.
For the respondents.
I am appearing for respondent number 5.
Is it there for the state?
Yes.
Yes.
Your lordship, I have purchased on land. That land was acquired by the West Bengal Power Development Corporation, which is under government of West Bengal. Yes, your lordship. But without paying me any compensation, they are using my land, digging my land, and taking the mud for coal mining, your lordship.
Your lordship, I am appearing for the Power Development Corporation. I have instruction that let them file a proper representation before us and the district magistrate. We shall consider it.
Yes. Representation to be filed before whom?
District
I have-
magistrate.
Have you filed a representation?
Yes, your lordship.
It was filed earlier in 2022.
2020. For 34, 33 and 34. 34 district magistrate and 33 is West Bengal Power Development Corporation Limited, Corporate Limited. 34 district magistrate, your lordship.
Let this be considered.
If they make a fresh representation, let them make.
Your-
What's the difficulty in this? Yes, let this be considered by the district.
Yes, your lordship.
It is contended on behalf of the petitioner. Surrogate affidavit service. That the West Bengal Power Development Corporation Limited has been utilizing a portion of the petitioner's land and are stacking mud in the process of removing coal in the project operated by the corporation. Page 34 is a demand of justice. It's not a representation. So please file a fresh representation. A
That
copy
is
of-
my instruction, my lord. Let them file a fresh representation.
All these are demands of justice.
Your lordship, page number 36.
Seek fair compensation.
Yes, your lordship, page number 36 to the district magistrate.
36 is also a legal notice.
Okay, your lordship.
The petitioner seeks compensation from the authority for acquisition of his land. Stop. The petitioner seeks liberty to submit a comprehensive representation before the concerned authority and prays for a direction of comprehensive representation in this regard before the concerned authority and prays for a direction upon the authority to consider the representation at the earliest. Paragraph is submitted on behalf of the respondents that the fourth respondent.
Yes, madam.
Fourth respondent be directed to consider the representation in accordance with law. Paragraph in view of the above, the petition is disposed of with liberty to the petitioner to submit a comprehensive representation ventilating his grievance before the fourth respondent within 15 days.
Lordship.
Within 15 days from date. Stop. The fourth respondent is directed to consider and dispose of the representation within 1 month.
Lordship.
Within 1 month from the date of receipt thereof, upon affording reasonable opportunity of hearing to all the stakeholders, including the petitioner, in accordance with law. Paragraph, the decision taken by the authority shall be communicated to the petitioner within a week thereof. Disposed of. Disposed.
18. In this matter, petitioners are essentially seeking for a disposal of the writ petition in the light of your lordship's earlier judgment passed in September 2022, which has been carried in appeal. Appeal is running in before the honorable division bench. Today it is in item number 24. Well, kindly adjourn it for a fortnight.
1 month, my lord, because my lord, there are.
My lord, the status quo order is there, my lord. My lord, in this appeal, my lord. The
Status quo is not concerned with the writ petition. In that event, my lord, I can
Isn't it?
how this submission comes. Status quo is there. Only adjournment, simply adjournment. My lord, let some date be fixed.
On
Item
behalf
number
of the
24.
petitioner, the matter is adjourned. Paragraph, let the matter appear under the same heading on 15th September.
Lordship.
আমি তার কাগজটা নিয়ে নেবো তাহলে, কারণ আমি তো নামগুলো দিয়ে দিচ্ছেন, তাহলে আমার তাহলে জানলে সে তো তারা বড় তখন তারা কাগজগুলো দিয়ে ফেলতো নামগুলো দেওয়া দরকার।
In this matter, I am for the petition.
On a private respondent,
My lord, the petitioner,
আমি তো দিয়েছি ন্যাশনাল হাই, তুমি দেবেন কি করে? ন্যাশনাল
the
আমি তো
respondent number 9 and
আমার পাওয়ার জমা দেওয়া আছে, উনি কি করে? সো কি মুশকিল?
Yes,
the respondent number 8 and 9, 9 and 10 moved a writ petition before this court, my lord. Alleging that we are obstructed their ingress and ingress. My lord, it is not a fact that we have obstructed our structure, small tea stall or stall on the road.
is your prayer in the petition?
Where we have the executive engineer, assistant engineer, page 30, my lord. Order to remove or demolition my structure, my lord. My lord, the respondent number 9 and 10 also encroach the government land.
This is a 10-1 notice.
Yes, my lord.
So you will have an opportunity of hearing before the authority. You cannot challenge a 10-1 notice before this court.
Yes.
Under 10-3, you will have an opportunity of hearing before the authority.
Yes, my lord.
So you can place your case.
My lord, I have made a represent unless I supplied the copy of the some documents. I am not in a position
This
to.
court will not deal with this matter at all, sir. This is a very early stage, 10-1 notice is there.
But it is my lord. My lord, kindly come to page 30, my lord.
Page 30, yes.
My lord, send the undersigned hereby order to clearly remove or demolish structures
By,
by 12/1/2023.
and we are in August.
Yes,
So your structure has been demolished?
no. As I have filed this writ petition,
It will not be there is no stay.
no.
Under 10-1, a structure is not demolished, sir. You must be aware. You'll have an opportunity under 10-3 to lead to adduce evidence. Yes?
No. I have not prepared any appeal against.
You have not reached that stage as yet.
10-1 এর পর 10-2 তো 10-3 তোমার হিয়ারিং এ ডাকবে, তারপরে অর্ডার 10-2 অলরেডি ফাইল, 10-3 পেন্ডিং
10-3 pending.
পেন্ডিং বিফোর দ্য তমলুক এসডিও।
You'll be given an opportunity of hearing.
My lord,
This writ petition has to be dismissed.
I dispose of.
Dismissed. Cannot be disposed.
Dispose of.
না
It has to be dismissed. You can withdraw if you want. Do you want to withdraw?
উইথড্র করবে?
It has to be dismissed, not disposed.
Then, my lord, I want to withdraw this writ petition.
But no liberty because you don't need a fresh cause of action. Learned counsel for the petitioner submits that he has instructions. No, submits that the petitioner does not intend to proceed with the writ petition any further. Paragraph in view of the above, the writ petition being WPS as such is dismissed for non-prosecution. There shall however be no rest clause as is set by website copy.
Account
With
of
the evidence
transfer.
websites.
my lord. Thank you.
20.
My lord, earlier, my lord, you lordship directed to submit a report regarding, my lord, this acquisition, my lord, the bus stand, my lord, has
আগে হয়েছে?
Stated.
had constructed.
I am for SBSTC, my lord. State has to file the report regarding acquisition. I don't know, there's one preliminary objection, my lord, from our end. State will also possibly take, my lord. In this case, my lord, they have challenged the action of the state authorities in a suit. Suit was contested, decree was passed that they will get compensation as per market value. That was in 2018. Nobody has challenged that decree as per their averments. In that case, my lord, he will have to get the decree executed. He only, any further claim possibly he cannot make because that will be barred by res judicata.
Page 24, my lord, kindly see.
And
Page
who is
24, the
appealing
decree.
state? I do not find anyone.
The page 24, the decree.
Who is appealing for the state?
ছিল?
Huh?
State is served.
No, earlier appeared, kindly see the order.
Earlier appeared. The SBSTC, Mrs. Ria Ghosh, who is she?
Her junior.
Oh, she appeared for
She
SBSTC, not Mr. De, please have a copy to it.
আমি তো বলি তুমি স্টেটে দাঁড়িয়ে আছো।
না না আমি এটাতে SBSTC
Kindly see page 24.
Yes.
The plaintiff right title and interest over the Core 1 schedule property is hereby declared. Core 1, kindly see the decree. Page 27. 7 decimal, 2 decimal, and 22 decimal. 3
Yes.
plots. Then further directed, the plaintiff is entitled to get compensation of only 1 decimal of property. After going through this, the fact, learned judge came to a conclusion that this plot has never acquired by the state. Only state acquired only 0.1 decimal. As such, this petitioner is entitled to get compensation in regarding 1 decimal land, and this land never acquired, but the SBSTC constructed bus stand without any process acquisition, without payment of any compensation. This is the kindly see my representation demand notice.
You have received compensation for this 0.
No, that portion execution is pending. Regarding is other 22 decimal, 7 decimal, and that land also.
তিনটে বলছে তিনটে পরে তাহলে
So this core schedule property is subject matter of the writ petition.
Yes, core 1.
মানে 1 decimal
Core 1.
ওখানে ক decimal
But kindly see page 24, plaintiff right title interest over the Core 1 schedule property is hereby declared. Core 1, my lord, page 27. Kindly see that.
Pray for a declaration before the suit court and recovery of possession before the writ court.
Yes, but declaration.
Yes, that is what you have done.
Declaration and my lord, declaration and my lord is a compensation. Recovery of khas position, this is not. This is not a recovery of khas position. If recovery of khas position, there is then execution court, executing court can recover the position.
Oh.
There is no recovery of khas position.
Judgment was passed on
Judgment passed
September 2018.
September
Yes.
September
6th day of August 2018.
But suit was for possession also. If I am not incorrect, not page 17. Page 17, first line. This is a suit for declaration of right, title, interest, possession and permanent injunction. So they have prayed for possession also.
So how have you come before the writ court?
No, there is no recovery of possession. Possession means but there's an interim injunction. State debarred from restraining from taking possession of this land.
So you say that you were in possession when the suit was decreed?
At the time of decree, my lord, the SBSTC already constructed bus stand.
So that time you did not pray for recovery of possession. How can you come before the writ court?
But writ court, the state, the SBSTC is the state authority without any acquisition, without any process of acquisition, acquired the land and
the situation was the same when the suit was filed. There is no change of circumstance.
No, this is the change of circumstances. Suit when the suit was filed.
Was the possession taken subsequent to the decree? No.
No.
When the suit was filed, you were not in possession. Isn't it? So you should have prayed for recovery of possession before the suit court.
But after the decree already passed, after decree, the state, initially, is the vacant land. After decree, the state already, there's a boundary wall has been constructed.
That is before decree or after decree? That is
After decree, after decree, the
so
boundary.
Please show me the plaint of the suit. I don't think so.
ডিগ্রিটাই তো ঠিক মতো ডিগ্রি না বলতে পারেনি যে ওর ইয়ে দাও ডিগ্রি কি রাইট টাইটেল ইন্টারেস্ট hereby entitled to the conversion of the 0.1 decimal of land my lord whether the petition is maintainable here.
That is my question. That's what I'm asking.
That is, my lord, if your lordship will see the degree, my lord, at page 26.
As per Article 300A, state without any process and acquisition, acquired the land and constructed.
The matter has already been decided by the suit court.
No,
There
suit
was
court,
no
suit court, they only decided that this is an acquisition or not. This land is the only declaration that this land never acquired. There is no, suit court has no right to against the acquisition. Acquisition, civil court is bar. Only declaration that this land never acquired. Only declaration. This is not a suit challenging the acquisition. State never acquired this land. SBS station.
Your submission is something and your plaint is something else totally. Have you seen the second prayer? আরজির ক এক তফসিলের কোনো অংশ প্রতিবাদীগণের দ্বারা অধিগৃহীত না থাকা সাব্যস্ত হয়। That is acquisition. How do you make this prayer before the writ court?
One land, this never acquired, only
This is your plaint. You made the same prayer before the suit court, rightly or wrongly.
no.
The second prayer.
In this writ petition, my lord, writ petition, my lord, I prayed, my lord.
Suit, the plaint. Identical prayers in the plaint, and it has been considered. Please see your plaint prayers.
But kindly see the judgment which was delivered by the
Yes.
suit court.
The prayers of your plaint entirely has been considered. You have not preferred an appeal against this judgment.
But this judgment, my lord,
The property has already been dealt with in the suit.
ডিগ্রিটাও তো প্রপার না টাকা বলে দিতে হবে তো।
kindly page 24 of that bullet, kindly see the decree. Decree plaintiff's right title interest over the core 1 schedule property he has been declared. But the core 1 property, kindly see the judgment decree, page 27. Core 1 properties 7 decimal, 2 decimal, and 22 decimal. Who are the party of the suit? The state land acquisition collector is also party, state of West Bengal also party in that suit.
That's exactly the reason why I say that this.
The state, our case is, I am the admittedly owner declared by the landed court below. There is no dispute regarding the ownership of the property. How the state, the SBSTC, they have constructed a bus stand without acquiring any land by the due process of law.
Please come to paragraph 6 of your writ petition.
Paragraph.
Respondents have an obligation to hand over possession. That is in terms of the decree of the court. But there was no decree to hand over possession. There was
No, decree is, I am the owner. This is the declared.
When the decree was passed, you were not in possession.
Yes, I am the owner. This is the court declared.
You were not in possession of the land when the decree was passed.
Yes,
Yes.
Yes.
Did you pray for recovery of possession before that?
In the suit, there is no such prayer. There is recovery of possession.
So how can you make the same prayer before this court?
No,
You were already not in possession when the suit was filed.
Constructive res judicata. Could have claimed. What he could have claimed, that is also bad.
Kindly see my prayer in the declaration. Well, a writ in the nature of mandamus commending the respondent authority, particularly SBSTS, to release and hand over the possession of the land in favor of.
That is recovery of possession. You have changed the language.
But if, my lord, the state authority, my lord, acquired the land without due process of law, my lord, then the state has an obligation to hand over.
This court could have dealt with the matter if there was no suit. The matter has been dealt with by the suit, by the civil court. A decree passed, you have not prayed for recovery. So you cannot correct your mistake done in the civil court.
But then the multiply, then, my lord, again I file an application suit for recovery of possession.
You have to.
No, my lord, because, my lord, if, my lord, the state authority.
Possibly suit will not lie because not constructive res judicata.
Yes.
Yeah, but because, my
Only
lord,
remedy is getting the.
the suit.
There was in fact a prayer for recovery of possession which has not been dealt with by the court.
There is no such suit for, my lord, declaration and permanent injunction. Well, there is no suit
Possession
for
also. Possession.
recovery
also.
of possession. Well, there is no recovery of possession.
So when you are not in possession and you don't claim recovery of possession, who suffers? The writ court will not intervene, sir.
No,
You can take instructions and come back.
But I have brought the decree. Well, decree never challenged by the state authority as well as the plaintiff. But decree is binding upon between the parties. But decree says that the petitioner is the owner of the property. Well, if, my lord, the petitioner owner of the property, my lord, how the SBSTC, my lord, acquired the land and construct bus stand?
My lord, as per decree, why is not execute the same before the lower court, my lord?
Execution is not possible. This is not a recovery of.
Order 2, rule 2 probably is a
Yes,
part.
my lord, as because that
Constructive res judicata also.
as per present market value of the
The prayer
property,
is not dealt with, then also it is barred. Shall we deem that the prayer?
he must go there, my lord, if he wants to get something. That is the money should হয়ে যাচ্ছে ততক্ষণ তো 3 বছর। এটা তো 12 years।
নাও থাকে
হ্যাঁ।
তাহলেও prayer which she could have made সেটাও তো
রিকভারি তো দরকার নেই, ও তো চাচ্ছে মার্কেট ভ্যালুতে টাকা। হ্যাঁ, সেটাই ওখানে গিয়ে ডিগ্রি কেটে করুক।
No, market value is a compensation regarding only 1 decimal. The learned court hold that the acquired only 1 decimal of land out of Malad Co 1 schedule.
সেই জন্যই তো তোমার
31 decimals land, total land, Malad Co 1 schedule. Malad the state
I
acquired
don't
only.
know how your suit has been decreed. Your prayer is not to disturb peaceful possession, but you are not in possession at all, isn't it? So how did you make this prayer not to disturb your peaceful possession?
No, but the court, Malad, declared the suit. Malad, court only declared the suit. The petitioner is the owner of the property, and further directed decree that the petitioner is entitled to get compensation only 1 decimal. But this is the decree. This is the decree passed by the court. But admittedly, petitioner is the owner. But now at present, my lord, the SBSTC is not at all owner of the property and not acquired the land. Well, then, my lord,
I asked you a preliminary question, whether the plaintiff was in possession when the suit was filed. You said no. Plaintiff was not in possession.
well, this is not a challenge by the decree before this court. Well, it's a wrong decree, is binding between the parties. If there is a wrong decree, it's binding
Matter
between the
has been
parties.
dealt with by the suit court. This court will not deal with the matter afresh.
No, this is not
I'm
a
not on the decree, the suit, nothing at all. The
No,
writ court cannot do that.
But suit court, but this is
Please
not.
come back some
But
other day.
this is not an execution of this decree. But this, I do not pray that the execution of the decree. But my contention is, well, the state authority acquired the.
Please come back some other day.
Before rising that notice, wanted to know the notice, the demolition will be made in the morning.
Tomorrow morning, sir. I said
to-
10:30 tomorrow.
But
We will
tomorrow,
not entertain this here.
tomorrow is the demolition, but tomorrow.
Heard learned counsel for the councils for the parties. Paragraph, let the matter appear under the same heading for further consideration. On 4th September,
my lord, your lordship appoint,
4th September.
your lordship appoint me, otherwise my lordship.
Yes.
Lordship.
My lord, none appears for the state respondents dismiss service. We mentioned.
My lord, before your lordship rises, my lord, the very next matter, item number 21. My lord, I was praying for some time, 2 weeks time, my lord.
It's not called.
Tomorrow.
24 before us. আরে আমিও তো চাই
কোন ম্যাটার?
কেউই নেই স্যার, আসেনি কেউই নেই।
Item 88.
Time.
88 first matter. 3004.
Anyone appearing?
It has been passed.
None appears on call. Paragraph, it appears that the petitioner is no longer interested. Wait, this was default. Can according to this. Next.
Take it. 89.
Is this for default? Can already
SCT.
disposed of it. Can already disposed of.
90. Do it in.
This is for default.
'91.
This is for default.
92.
This is for default.
93.
This is for default.
94.
I am appearing, my lord, in this matter.
Lord, I appear for the petitioner, my lord. This writ petition, my lord, pertains to, my lord, refund of, my lord, penalty, my lord, taken on account of overloading, my lord. Our allegations were that, my lord, the way bridge was not functioning. And despite that, my lord, they have not checked. Subsequently, when they checked, my lord, it was found that it was actually not over. Now, my lord, on the last occasion, your lordship directed, my lord, the railways to file a report, my lord. And my lord, pursuant to your lordship direction, legal metrology was added. Mr. Debray was being served, my lord. He was also directed to, my lord, file a report, my lord. Till date, my lord, we have not received any report from any of the parties, my lord.
My lord, lordship kindly fix on next week, any day next week, my lord. Any day next week, my lord. In the meantime, myself, my lord.
My lord, Mr.
No.
Means he probably, my lord, Kollan Kumar Chakraborty was appearing for railways.
I do not find him.
Not here today now. My lord, he had taken on two occasions, he has taken extension, my lord, to file a report.
Let the state come with a report on the next occasion. If no report is filed, I'll take up the matter.
My lord, will kindly clarify that in order, because on first 20th June, my lord, order was passed, then 17th July, he seeks an extension, my lord, and today also, my lord, there is no report. আর আপনাদেরও আছে আমাদের আমরা কার হয়ে দাঁড়াচ্ছি legal meeting
None appears for the railway authorities.
added risk.
Stop, no report is submitted. Paragraph learned counsel for the seventh respondent seeks extension of time to submit the report as sought. Paragraph, let the matter appear under the same heading on 29th August.
My lord.
August.
No, seventh respondent. And still on my lord, the railway is concerned, my lord, there was 2 times there was a direction to my lord. Great.
My lord, instead of 29, let it be on 30th or 31st.
31st is a Thursday, I think. 30th.
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 Great.
Next. Respondents.
So far association is concerned, respondent number 7, my lord, I could not contact with him. But my grievance is against the respondent number 4. Your lordship kindly have a look, the order dated 23rd June. But after the order has been passed, my lord, correspondence is being
Have
made.
you served 7?
Yes.
Have you served respondent
Evidence
number
service.
7?
On 23rd, he appeared. On 23rd appeared, my lord. But your lordship, after the order passed by your lordship on 23rd June, several correspondence is being made. I have made a supplementary affidavit, copy has been served.
Yes, madam.
My lord, this fact involved in this petition, my lord. Petitioner was plying his vehicle in respect of one trip, one round trip, one up and one down. Since the route is distance of the route is very small, very short distance, but petitioner applied for the double trip, additional trip. But that additional trip has been allowed by the authority, but it has not been incorporated in the permit. Since, my lord, no timetable has been prepared and approved by the respondent number 4, who is the Regional Transport Authority, Purulia. My lord,
A report was called for from the state.
My lord, report was not filed, my lord, but he filed the supplementary affidavit. Your lordship will see this.
Your lordship,
Supplementary affidavit.
kindly have a look at the supplementary affidavit. After the order has been passed by your lordship, the Regional Transport Authority, Purulia, respondent number 4, issued a letter asking me to submit the class 3 timetable. That is the supplementary affidavit. That is the annexure A1.
Yes.
My lord, pursuant to this requisition, my lord, petitioner before your lordship filed, my lord, page 9. My lord, all the suggested proposed timetable, page 10. And my lord, as asked by the authority, RTO, my lord, petitioner submitted all the relevant timetables of the other operators on the route in question, in order to substantiate that there is no timing class. Well, in each and every point, my lord, you will also kindly have a look, the page 12, 13.
Yes, yes.
But this letter was submitted before the authority on 17th July. But thereafter, the authority issued another notice, but page 15. My lord, last line. Hence, you are advised to submit class 3 timetable indicating vacant time for your bus from Kasipur. But it has also been submitted by the petitioner on page 17. And this is the timetable at the point of Kashipur, page 19, page 20.
Yes.
No time class. Only single bus is plying on this route, my lord. But since, my lord, I raised a voice against the association, but my timetable has not been approved. This is the only point.
Yes, Mr. Dev.
Because, my lord, before moving these petitions, in each and every occasion, my lord, association was invited by the RTO for preparation in timetable.
My lord, as page 8, my lord,
Yes.
hence you are asked to submit a class-free timetable for the additional tip of the ATO.
All
With
that is
respect to
submitted.
that, so my lord, you must pass the order, necessary order within 15 days.
You will also
from the
final
date of
timetable
the-
to approve it, my lord. This is a mere timetable. I am waiting from February 22, my lord. But there is no timing class. And if there is a timing class, I am ready to attend the office for attending the objection hearing. But there is no, and there is no impediment. There would be no impediment in the eye of law to approve this timetable.
According to RTA direction, my lord, he filed that. So, my lord, he must pass the necessary order within 15 days.
Without inviting association.
এখানে তো সেরকম কিছু বলা নেই, association কে ডাকতে হবে। লাগবে না, তুমি বসো। তুমি বসো ভাই।
The proposal will be considered in terms of these documents filed by you
Yes, my lord.
upon giving you a hearing.
Yes, my lord.
Yes?
My lord, till date, my lord, I may be allowed to
In 2
fly.
weeks.
Yes, my lord,
Within
within
2
2
weeks.
weeks.
I may be allowed to fly, my lord. But there is no
You
timing
are
class.
allowed to complete single trip.
No, my
You
lord,
are
you are
completing your single trip.
additional tip, my lord.
With 2 weeks.
2 weeks তো তোমার তো
And only in terms of your documents. That's all. Supplementary affidavit submitted on behalf of the petitioner is taken on record. Paragraph. It appears from the supplementary affidavit that during pendency of the writ petition, comma, the Secretary Regional Transport Authority Purulia requested the petitioner to submit the clash-free timetable for the additional trip for the route Kashipur to Purulia, which was complied with by the petitioner. V-Day letter issued on 17th, V-Day letter issued on 12th July 2023 করুন এর আগেরটা রিকোয়েস্টেড যেখানে বললাম না ওখানে the secretary requested এর আগে the secretary regional transport authority Purulia comma V-Day letter issued on 12th July 2023 comma requested
Respondent number 4 here in my
petitioner by the petitioner by a letter submitted on along with a letter submitted on 17th July 2023. Stop. Upon receipt of the same, comma, the authority again requested the petitioner by a letter issued on 19th July 2023 to submit that timetable indicating vacant time for the petitioner's bus from Kashipur. Stop. The petitioner complied with the said request by a letter submitted on 25th July 2023. Paragraph, learned counsel for the petitioner submits that despite complying with all the requests made by the authority, comma, the timetable submitted by the petitioner in respect of 2 round trips has not been approved.
Despite the authority approval in its board meeting.
কি বললাম এটা বলুন সেন্টেন্সটা, learned counsel for the petitioner submits.
Page 27, my lord, of the writ petition. Page 27 of the writ petition, my lord. This approval by the authority made on 20th September 2022, serial number 2. Page 27 of my writ petition. Serial number 2, Santipriyo Soren, file number 2. At the left column. Serial number 2. And this is the resolution of the RTA board meeting Purulia held on 20th September 2022. At the top.
Is this approval for?
Yes, my lord. It is a resolution.
Timetable is required, so
Yes,
it's not
ma'am.
approval.
So only it has been strict, approval has been strict to the approval of the timetable. But grant of second trip has been allowed.
Grant of second trip will be considered subject to,
Approval of the timetable,
subject to, yes.
class 3 timetable.
Submitting the class 3
So
timetable.
additional prayer for additional trip has been allowed.
It has not been allowed. to
And
be
this is the
considered.
resolution, my lord. This is the resolution.
Resolution says it will be considered. For additional trip, the timetable is required.
My
That
lord,
means it is being
single trip
considered.
already permitted, additional trip class 3 table is required.
Timetable is required, yes.
Is required.
It's required for consideration. So this is not approval of second trip.
But this is the resolution of the
Resolution doesn't approve the second trip. They do not say that the trip is approved subject to submission of timetable. No,
that is
it will be considered upon submission of timetable. That is the language. There is no approval as such.
resolution itself maybe is the approval.
No. Resolution doesn't mean approval. See the fourth file, approved subject to, this is approval.
3 and 4. Next 3 and
It has been clear.
This is approval.
This is
The
approval.
other earlier is not
I
approval.
developed.
That is required.
It will be considered upon.
I am developed.
কি বললাম একটু বলুন? Paragraph, learned counsel for the state respondents submits that the fourth respondent be directed to consider the issue in accordance with law. Paragraph, in view of the above, this court is inclined to hold that since the petitioner has complied with all the paraphernalia as laid down by the authority, comma, the authority be directed to consider issuance of the timetable as sought within a stipulated time frame. Paragraph, the writ petition is accordingly disposed of, directing the fourth respondent to consider issuance of, approval of
approval of the class 3 timetable for additional trip.
approval of the clash free timetable for the second
On
for
the
the
additional trip.
additional trip
Submitted.
for the route Kashipur to Purulia in favor of the petitioner in terms of the resolution
20.
taken in the board meeting held on 20th September 2022 and upon affording reasonable opportunity of hearing to the petitioner within 2 weeks from the date of communication of this order, comma, in accordance with law.
But only one thing, my lord. My lord,
The decision taken by the authority shall be communicated to the petitioner within a week thereof.
only one thing, my lord. But your lordship has hold has passed an observation in order dated 23rd June that in any event, but while consideration of my application, that the association, the despot number 7 should not be invited. Otherwise, the entire game would be frustrated. Your lordship has already hold. Your lordship kindly I go online. But
Paragraph, it is made clear that the authority shall not invite the opinion of the 7th respondent in dealing with the issue.
Yes, my lord.
Disposed of in accordance with law. তারপরে এটা দেবেন, তারপরে there shall be no order as to cause affidavit আর ওটা 3 লাস্ট 3 লাইনের আগে দেবেন।
And deemed lawless.
Next.
96.
But in this matter, I am for the petition.
Straight with Mr. Dev.
This is the affidavit of service, my
I
lord.
am appearing, my lord.
No, yes.
I am appearing, my lord.
And one supplementary affidavit has also been prepared after servicing. Take my lord. My lord, in this matter,
Yes.
my lord, petitioner's prayer is simply seated for counter signature of the order of replacement of a vehicle by the made by the state authority Jharkhand. My lord, after the order,
Counter signature by Jharkhand or West Bengal?
no, West Bengal. I am seeking, my lord, I am seeking order, my lord, for against the inaction on the part of the STA West Bengal in countersigning the order of replacement made by the state authority Jharkhand. My lord, it is a very old permit, and petitioner before your lordship is not only protected under Article 15(3), 15 surplus 3 of the Constitution of India, but also as cancer patient. My lord, petitioner's permit is of, my lord, 2000, is of 1991. 1991 is the permit, my lord. My lord, what happened, my lord, what the vehicle was placed in the permit, that is of 2010 model. And it is the policy decision of the STA Jharkhand that no vehicle can be allowed to be replaced if it attains the 12 years age. But before this vehicle attains 12 years age, I replaced another vehicle of 2015 model. That has been considered in the board meeting of the STA Jharkhand. Though, my lord, earlier vehicle was BS3 and this vehicle was also BS3. But after the order of replacement is being made by the authority, STA Jharkhand, one letter has been sent to the STA West Bengal for granting counter signature to that effect. My lord, page number, my lord, that is page number
15.
Yes, my lord. I am developed, my lord. 15. My lord, pursuant to this letter, my lord, your lordship kindly come to the page 29.
Yes.
My lord, pursuant to this letter, the RTO and ex-officio assistant director STA West Bengal, by its letter dated 15th June 2023, directed the taxing officer PVD to accept the tax in respect of the replaced vehicle of the petitioner for getting it countersigned. Accordingly, I have paid. Next page, 30.
Yes.
13,220 I have paid immediately. But still then, my lord, no replacement order was countersigned, my lord. No countersign made. I came before your lordship. Moment I served the copy of the writ petition upon the authority, my lord, now your lordship kindly come to the supplementary affidavit.
Yes.
My lord, page 15, my lord, of my supplementary affidavit. Your lordship kindly have a look the memo dated 10th July. My writ petition was filed on, my lord, 2nd August. This purported letter, my lord, was signed on 3rd August. Your lordship kindly have a look at the bottom. 3rd August. And this letter has been posted on 7th August, which has been received by the petitioner, my lord, on next page 16, on 12th August. So how, my lord, my legitimate claim and expectation, my lord, is being frustrated by issuing this order? And page 17, my lord, when it was posted, your lordship kindly have a look. 17th, it was booked, and it has been served on 12th August. But in this letter, my lord, one purported resolution of the STA West Bengal has been taken into account. That is, my lord, resolution dated 8 December 2022. Second paragraph.
This is for new application.
Yes, my lord. No, my lord, I annexed. My lord, page 20, page 19 and 20. That is the purported resolution. Henceforth, no new interstate permit and replacement of vehicle will be countersigned if the vehicle does not possess pollution norms less than BS4. Maybe, my lord, it is a policy. But this policy has been turned down by the next page. That is the notification of the Transport Department, page 21. Transport Department. And that resolution is of the authority. Your lordship kindly have a look the page, next, page number 24. The operative portion of the so far the replacement is concerned, by the page 24. Clause B, subclause C, page 24.
Yes.
Replace clause C. I will also formulate. Replacement of vehicle should be encouraged to be made by higher model vehicle or at least by similar technical specification, including BS norms, age of the existing vehicle in compliance to this order in terms of Rule 153 of the West Bengal Motor Vehicles Rules 1989. Now, your lordship kindly have a look. The section 83 of the
Subject to decision of the respective transport authority.
Subject to decision of the respective transport authority. So this is the policy of the Transport Department. But your lordship kindly now kindly have a look at the section 83. So for the replacement of vehicle is concerned. May I hand over, Manu?
Yes, 83.
Section 83, replacement of vehicles. The holder of a permit may, with the permission of the authority by which the permit was granted, replace any vehicle covered by the permit by any other vehicle of the same nature. My earlier vehicle was of BS3. My replaced vehicle is of BS3. Only higher model. From 2010 to it has been 2015. So same nature. So there is no, well, there is no impediment in the eye of law to grant replacement as per section 83. Now your lordship kindly have a look at rule 153.
Central rules.
West Bengal Motor Vehicle Rules. Well, rule 153 does not prescribe the authority to reject my application. Not a single ground is there to reject my applications if my lord rule 153 taken into consideration as a whole.
Yes.
If the holder of a permit to a particular vehicle by specification of the registration marks desire at any time to replace the vehicle with another, he shall forward part A of the permit. It has been done in my permit issuing authority. So my permit issuing authority has had that power either to allow or reject my application, but my application has been allowed. Since there is no embargo. Now your lordship again.
153 is the domain of the permit issuing authority.
Permit issuing authority or grant replacement granting authority.
Yes.
My lord, next, my lord, your lordship kindly have a look. The same policy has been adopted by the Transport Department, latest, my lord, on 2nd June 2023. That is, my lord.
Revised guidelines.
Yes, my lord. Page, your lordship kindly come to the page 25 starts and operative portion 28.
Yes.
Same clause as of my lord, same clause. So my lord, policy of the Transport Department has been regularized and enhanced, my lord, in the two consecutive notification after the impugned resolution was passed on 22nd August 2022. What has been reflected in the rejection order in my case? So this order ought to have been reflected in the impugned rejection order, this government policy, but that is silent, totally silent. Now your lordship kindly have a look. The petition is a cancer patient, page 29. More so, my lord, there is no impediment in the eye of law, and there is no embargo, my lord, in the eye of law to reject my application. And my lord, your lordship, and your lordship has heard in my one case that is fixed on 29th, that the Honorable Supreme Court has specified that no vehicle below the age of 15 years should be disallowed. Your lordship has occasion to look into, my lord. Yes.
Yes, Mr. Devra.
Yes, lordship kindly see, my lord, on the decision, my lord, taken by the STA that has, my lord, communicated to the STA Odisha regarding, my lord, restriction regarding BS3, BS4. In spite of that, they have granted permit to BS3 vehicle. It is not bounden duty of the STA West Bengal to countersign the vehicle, countersign the BS3 vehicle, because STA West Bengal already took a decision in the year 2020 and November 2020, and that has been communicated to the STA Odisha. In spite of that, my lord, they have granted permit. This is not fault on the part of the
2022, not 2020.
2020, yes, my lord, deep 2022. So, my lord, in that one identical issue, my lord, now say, Arif Hossain matter, my lordship already direction for affidavit. Affidavit is ready. I think today or tomorrow he will serve this affidavit opposition. It's identical issue. Lordship can fix next week any day. I shall be present in physically, my lord, regarding that matter.
Yes, already rejected the prayer. The instruction is here. By the SPA, it has been communicated.
মেমোতে দেয়া আছে দেখো।
No, no,
affidavit দেয়া আছে।
আমার instruction আমি যাবো।
STA Jharkhand may be wrong or may be right.
What about the notification issued by the government?
2nd June, matlab there is a notification regarding guideline for granting permit or counter signature of military
Please come to
permit.
the notification. Please
2nd
come to
June.
the notification. Yes, 2nd June.
Yes. My lord.
The last page, BC. Clause BC.
Page 28 of the supplementary.
Page 28 of the
Supplementary affidavit.
Of the supplementary affidavit.
So lordship kindly, I think my lord, the better lordship kindly fix the matter on 29. I'll be there along with that matter. I shall my lord, agitate the view.
No, my lord, your lordship kindly consider the.
No question of patient
Medical.
or like that. Well, they can law,
Kindly consider
municipal law is laid down.
But Mr.
They-
Devra is always free to
we are
use
complying the
report
order
or
passed by
affidavit.
the apex court.
Anything. I'm just adjourning the matter to
Now,
29.
then, my lord, your lordship,
Physically appear before the court on 29.
then, my lord, I want to ply my vehicle, my lord.
How can it be?
That has been withheld.
This is next week.
Now, your lordship kindly have a look. The similar order was passed by this honorable court, but the other coordinate bench. But in the meantime, I should be allowed.
Why coordinate bench? This court
Why?
has passed an order for, has called for affidavits in a similar matter.
No, my lord.
In this matter, I'm
Yes.
not
But
for affidavits.
if the order of replacement is being withheld, counter signature is
I
withheld.
cannot allow you to ply without a counter signature.
My lord,
Deep reply.
the counter signature is being withheld. But your lordship kindly have a look the order.
That will not help you, sir. I'm sorry.
Your lordship kindly have a look the order, my lord. But this matter was also pending. I have been allowed to ply, subject to payment of tax.
I'll release the matter, go view the coordinate bench. I cannot grant you this relief in here.
Your lordship kindly consider the predicament of a poor citizen,
What
poor
it is?
operators.
No, it is a
Well,
policy.
They have not made any fault. But petitioner has not made any fault. Petitioner
Framed by
payer
the
has been allowed by his permit.
Apex court framed by the apex court. As well as National Green Tribunal.
And this is the permit of 1991. A number of persons is dependent upon this transport service. And your lordship has ample power, my lord, your lordship.
This is a different issue.
Yes.
This is not counter signature.
Counter signature.
A request was made to restrict the permit in respect of a single vehicle. This is not counter signature.
Counter signature, my lord. Matter issue relates to counter signature.
I do not know, my lord. I don't know.
And at the bottom, my lord, it has been ordered that the my lord, till such.
But this is not counter signature. Please show me one line which says that it is counter signature.
Yes, it is counter signature.
Please show me one
I
line.
didn't.
Otherwise, I'll dismiss your petition.
Your lordship kindly consider this, my lord.
wrong
Unnecessary, my lord. Unnecessary
Come
hacking.
back on 29.
Unnecessary.
14 কত চলছে 14 স্লো
The last line, my lord, your lordship, last line, my lord.
Yes, what is the line?
Accordingly, the petitioner shall be entitled to ply his vehicles on the route as plied by him
Where is
earlier
the counter signature
when
issue?
until further orders of this court.
Yes,
the-
where is the counter signature issue? Mr. Bhattacharya, please do not refer to wrong orders.
Counter signature means grant of permit also. That is
Altogether. Affidavit of service and supplementary affidavits submitted on behalf of the petitioner are taken on record. Paragraph heard learned counsels for the parties. Paragraph on prayer of the state respondents, the matter is adjourned. Paragraph let the matter appear under the same heading on 29.
29 or 30, any lordship can fix anything.
29.
Other matters
29.
29.
29.
29, yes. Yes, I have no objection.
I'll add one line, the interim order is paid for as being refused.
No, why?
What
I am
interim
paying for
order is
interim order, my lord. I'm praying for
Question of
till
interim order.
till such
BSc
consideration is
vehicle.
given, I may be allowed to ply my
He is
vehicle.
always
I have
insisting
been-
BSc
since I have
vehicle.
been granted permit.
Paragraph. Learned counsel for the petitioner seeks an interim order allowing him to ply the vehicle till the issue is
Lord,
decided.
kindly consider it, my lord.
Paragraph. The prayer of the petitioner permitting him to ply the vehicle without a counter signature cannot be considered and is therefore rejected. Next. August
97.
Lord, I appear for the petition in this matter. Data given.
State, Mr. Banerjee.
Lordship, I am told Mr. Anand Banerjee is appearing for the state.
Yes.
He is on lakes in other court.
Lord,
So I am-
My lord, on the last occasion, he was here, my lord. My lord, on the last occasion, the service of the private respondents was affected and it has been returned. Lord, you'll also kindly see the evidence service. Lord, one has been returned with the remark unknown, although it has been sent to the proper address, and another was returned with the remark refused.
Refused is proper service.
Proper service, but I could not annex it because
Not
it was
known- Not known is not proper service.
no. It was sent to the address given in the permit itself. The permit which has been annexed in the petition, on that address it was sent. Wherein this remark was made not known. I've annexed the permit at page, my lord. At page 14. Kindly see the address. Same address it was given.
And where is the refusal?
Refusal, that letter was returned today. When I came to the court at 9, it was not available. At 12, it was returned. I am told by from my house that it was returned with the remark refused. Lord, your lordship can take up the matter tomorrow since my learned friend is not.
You have to make a substituted service in that case.
Yes.
You have to make a substituted service. Not known cannot be accepted.
Your lordship kindly see in the permit at page 14.
He
This
may have shifted. He may have shifted his residence. Because you have to serve, he is an affected party. You have to serve and come back.
my lord,
You can file an application for Order 5 Rule 20.
yes, my lord.
You can file an application under Order 5 Rule 20, substituted service, if it's not possible in the ordinary manner. Can't help, sir. You have to serve and come back.
In that event, your lordship kindly expunge the name of the respondent. Your lordship kindly expunge the.
Not an interested party.
My lord, I am told he is not at all interested. You will also kindly expunge the name of respondent number. Respondent number 6. 6. He may be expunged. His name may be expunged from the petition. My lord, only my lord, an objection has been raised with the authorities that whether one permit can cover two permits one vehicle can cover two permits at a time. This objection was raised with the authorities. But let them decide the objection as to how one vehicle can cover two permits at a time.
Will you come back with the refusal tomorrow? Shall I make it not?
Yes. Keep it tomorrow, my lord.
I'll keep it not today.
Keep it tomorrow. I shall produce.
I just make it not today. Please inform Mr. Banerjee. Is it not today?
My lord, may I take back the
Yes.
evidence service so that I can annex it and give it to your lordship? And the name of the respondent number 6 may be expunged.
I'll do that tomorrow.
Very well.
Because I'm just making it not today.
Yes, my
I'm
lord.
not passing an order.
Very
Today.
well.
Please come back tomorrow.
98.
Well, I am appearing, my lord.
I beg to appear for the petition, my lord.
My lord, the service of notice is awaited on the private respondents, my lord. Make it not this week, my lord. In the state of Jharkhand, they are living, my lord. I have sent, my lord. Not yet, my lord.
Since
Effected.
30th matter is 30th August.
30th.
August.
Can you,
30th August করে দিচ্ছি।
can you complete by 30th?
Yes, yes, my lord.
Since service upon the private respondents is not is not complete. Paragraph, let the matter stand over till 30th August.
Lordship, on behalf of state of Jharkhand, I'll accept the notice. Lordship.
This is the private respondents.
Private.
Private respondent.
এইটা 30
এটা তো আপনার নাম্বারটা দিন আমি তো দিয়ে দেব। Grateful, my lord.
Deep look.
Okay, 7th August.
7th August. 7th
Matters from monthly list. Item 995.
But in this matter, I am for the petitioner.
Lord, I beg to appear with the state respondents.
I have made an application for addition of party.
Today it is for hearing of the matter relating to application for addition of party.
Yes, ma'am.
Let my learned friend place his application for addition of party, then I shall answer.
You're opposing the
Yes,
application?
yes.
This particular matter, my lord, it has a checkered history, my lord. Your lordship kindly come to the page. Page 39 of the writ petition, lordship. This is the initial notification. There was a route number 30C and 30C by 1 mile. The 30C that is flying from Bandstand to Hatiara, and 30C by 1 mile, that is from Outram Ghat to page 39 of the writ petition. Annexure P4. This is the initial notification which was published in the year 2016, my lord, June 30 to 2016, in respect of two routes, route number 30C and 30C by 1. And by way of this notification, my lord, the initial strength which was granted by the Transport Department, Government of West Bengal as 25 each route, that was enhanced by 10 number of permits, my lord. The 50.
This is an amendment notification.
Lordship?
This is an amendment.
Yes, my lord. This is an amendment notification. The initial notification issued in 2016, the amendment made in 2003, my lord, the initial notification. And thereafter, amendment was made in 2016. That 10 number of permits in each route was enhanced, my lord. And in respect of this enhancement, my lord, several writ petition was filed, my lord. The writ petition was filed. The existing operator of the said route, that enhancement is not in accordance with law. And in terms of that, this honorable court was pleased to set aside the said enhancement, my lord. The order of the writ petition, that is at page 41. I will not trouble your lordship, that particular order, my lord, because this particular writ petition was allowed, and that was ultimately the order was passed in favor of the existing operator. The permit was granted in respect of the 20 permit holders. That was set aside, and the appeal was also preferred against the said order, my lord. The appeal authority, the order of the appeal, that is at page. That is at page 56 of the writ petition. The order passed by the division bench of this honorable court. And there was several observation made by the appellate forum, my lord. Lordship, kindly come to page 85. Paragraph 38 of the appeal court's order. Yes. Since therefore both the appeal fall on all points are good, we dismiss the appeals. Because the appeal was filed by the permit grant, in whose favor the permit was granted, that permit was set aside by the writ court, my lord. And this means that uphold the quashing of the impugned rescind order dated January 22nd, 2016, its correction by way of corrigendum dated March 4, 2016, and the notification dated June 17, 2016. I have initially referred that notification, my lord, published in the official gazette on June 30, 2016. And direct the appellant number 1 in MAT number such and such, being State of West Bengal, through its appropriate officer, preferably the Principal Secretary, Department of Transport, and if there is no Principal Secretary, then the Secretary, Department of Transport, consider and dispose of the representation made by the appellants in MAT number such and such as exhibited as annexure P3 of writ petition number such and such after due inquiry, as already directed by the order dated July 31st, 2015, passed in the said writ petition, without giving any opportunity of being heard to any person, but after satisfaction of the condition mentioned in section 71(3)(a) read with section 67(3) of the said Act of 1988, in the light of the notification dated August 2nd, 2004, published in the Official Gazette Extraordinary Part 1 on August 6, 2004, and in strict compliance therewith, and in compliance with the judgment in the said case of Sujata Ganguly, as expeditious as possible, but positively within the period of 3 months from the date of communication of this order, and give effect thereto. It is needless to mention that no effect can be given to any permit for stage carriage on the said routes issued after increase of free strength over and above those existing under the notification of 2nd August 2004, published on 6th August 2004. This will, however, not prevent the appellant in MAT number such and such and the added parties to apply afresh for permits if the fleet strength is increased after completion of the exercise mentioned above. Now, my lords, the last portion is very important. This order shall not prevent the appellant in MAT number such and such from seeking variation of their routes to ensure that they do not pass through the central business district of Kolkata. And if such representation is made, we are sure that the concerned respondent authorities will consider the same in accordance with law and pass the necessary order as expeditiously as possible. And this is the order passed by the division bench, one of the judge of this division bench. And the other judge, he has passed the order in a different way. The presiding judge, he has passed the order that is at page, the operative portion is at page 89.
Yes, that has been conquered by the second judge.
Yes.
I am placing the paragraph 5. And as by way of clarification, it is observed that by complying with the order of the coordinate bench dated July 31st, 2015, passed in WP number such and such, the competent authority may explore, the word is may explore the possibility of granting permits in favor of the appellants in MAT number such and other applicants for permits similarly placed for plying stage carriage between Hathiara to Satragachi by alighting the routes in such manner that the stage carriage, if at all permits are issued, do not pass through the CBD of Kolkata and or Howrah, which would be in consonance with the terms of the earlier policy decision contained in the notification dated 2nd August 2004, published in August 6, 2004. So, my lord, the two judges, they have given their views in two different ways. One has said that the appellant in MAT number such and such, they can pray for variation of their route by making fresh application. And other judge, the last or the presiding judge, he observed that authority can explore the opportunity to grant permit from Satragachi to Hathiara, but that particular route alignment should not pass through the central business district, that is Esplanade and Howrah station, and they can fly through another alignment. Now, my lord, what happened, my lord? Thereafter, the appellant of the said appeal, my lord, they have choose the first opportunity. That is the first preference. They have prayed for the variation of route. Variation of route means change of route, my lord. Now, what they have prayed, that is the application. They have made before the authority, my lord, they have prayed for in separate route, that is from Hathiara to SDF, that is in Salt Lake, my lord. And the authority concerned on 16th March 2020 decided the issue in favor of the appellant of the said appeal, my lord. Lordship, kindly come to the addition of party application.
Yes.
That is the order of the division bench. In terms of that order, my lord, the applicant before your lordship, they had preferred for apply in a separate route. And lordship, kindly come to page 20 of the.
Before the revision.
I am the appellant before the division.
Now, page number?
Page 20, my lord. Annexure A of my application for addition of party application. Yes, my lord. My lord, the authority decision. It's the authority decision. And lordship, kindly come to the agenda number 2.
Yes.
Yes, my lord. Can number such and such and State of West Bengal versus Abhijit Ghosh such and such. An order has been passed by the Honorable Division Bench High Court on 11th February 2020 in connection with the above writ petition on route number 30C and 30C/1, directing the Transport Department, Government of West Bengal to cancel the notification dated 17th June 2016 and to take decision accordingly. RTA board discussed over the matter scrupulously and perused the order passed by the Honorable High Court, Calcutta, and decided to give no effect to the permit 30C and 30C/1 issued after increase of fleet strength in this route. Now, the second portion, in observance of the court's order, the RTA board took decision to approve the variation of route as sought for by the operators, with a special vigil to the matter that the route so diverted must not touch CBD. The RTA board unanimously decided to intimate the aforesaid persons thus and apprise them of the approval of the new route as spread for Hathiara to SDF via Baguihati, Keshtapur, Lake Town, Ultodanga Station, TNB, Sia Island, City Center, Corunamoi, College Mode, 215 bus stand with the fleet strength of 20. The RTA board unanimously took the decision of approval of the presence of DC traffic and instructed to approach before the Transport Department, Government of West Bengal for the publication of necessary government notification. So, my lord, we have applied before the authority in terms of the division bench order. And in terms of that order, authority has recited our application. And in terms of this one, the authority approached before the Transport Department. The Transport Department raised their objection. Lordship, kindly come to page 23.
Yes.
Yes, my lord. The Joint Secretary, Transport Department, he wrote a letter to the Chairman, Regional Transport Authority, Kolkata, my lord, on 28th January 2021. On examining of the proposal received via your letter dated 31st December 2020 on the above cited subject, it has come to notice that to traverse through PNB point touching Ultodanga station, the bus in the proposed route will have to take U-turn from 15 number bus stand, where only the buses of West Bengal Transport Corporation and other state transport undertakings are allowed to entry. I am therefore directed to request you to re-examine the route alignment and resubmit the proposal along with the NOC from the Joint/Deputy Commissioner of Police Traffic Department. So, my lord, in terms of that objection, again the board had decided the issue. And again, we were asked to, several objections were asked from the traffic point of view. And lordship, kindly come to page 29, annexure F, lordship. That is also the board's resolution that was taken on 10th August 2021.
Yes.
Lordship, the agenda number 2, lordship. The RTA board discussed the matter and decided to obtain route alignment from the route operator as per the report of the DC traffic, Bidhan Nagar, vide memo number such and such. They now directed us to give the necessary alignment. We have given that in page number 31, annexure H. The details alignment, that is the subject of the letter. We have given that, and it was signed by the operator, that 20 operators. All the 17 was signed, lordship. Yes. And thereafter we move before this honorable court. Lordship, kindly page 33. by way of a writ petition that was disposed on 31st January 2022. The prayer of the petitioner is that representation made by the petitioner to the Secretary Regional Transport Authority, Kolkata region on 15th September 2021 for alignment of a particular route to be considered and granted in the light of no objection report given by the Bidhannagar Police Commissionerate on 15th July 2021 and the records of proceeding of the Regional Transport Authority on 10th August 2021. The submission of the Land Council appearing for the petitioner is supported on behalf of the state respondents. Land Council appearing for the state respondent submits in the meeting held on 25th January 2022. The prayer for concerned route alignment has been granted, and such decision shall be communicated to the petitioner in due course. And thereafter, my lord, the petitioner was again asked to appear before the board in terms of that decision, my lord. Page 35 is the board's resolution that was decided on 27th April 2022, lordship. The operative portion that is at page 36, the bold portion, lordship, to take decision accordingly. Excess 20 erstwhile permit holders of enhanced fee strength in the route number 30C and 30C/1 appeared and they were duly heard. RTA board decided to take decision after getting NOC from the DC Traffic Bidhannagar Police Commissioner. And finally, the no objection was given by the Bidhannagar Police Commissioner, lordship, that was at page 39.
Yes.
Yes, lordship. After getting that NOC from my lord, the authority, Regional Transport Authority, Kolkata, they have finally decided the issue on 30th August 2022. That is at page 43. Annexure N. The agenda number 1, lordship. It's a very big agenda, lordship. The operative portion is at page 45. I am placing the same. RTA board peruse the order passed by the Honorable High Court, Calcutta, dated 11th February 2020 and decided to approve the proposed route on the basis of the report of DC Traffic Bidhannagar Police Commissionerate and DC Traffic Lal Bazar, and to send the proposal to the Transport Department, Government of West Bengal, for publication of necessary notification after getting willingness in writing from the operator of excess 20 vehicles. That means the appellant in that appeal, my lord. And thereafter, the principal secretary was informed and a notification was published. That is at page 48. Page 49, lordship, the first paragraph I am placing. The additional director, Kolkata Zone Transport Directorate, West Bengal, and Chairman RTA Kolkata has requested for issuance of notification introducing the proposed stage carriage route Hatiara bus stand to Salt Lake Sector 5 via Jhil Bagan and such and such.
So the U-turn has been allowed.
U-turn has been allowed, my lord, and with the fleet strength of 20, with the condition that during the return journey we have to take the U-turn, and thereafter the route was formulated, my lord, and the route number was given as 30C/2, and the fleet strength was fixed as 20 because the 20 they are the 20 appellant before the appeal court. And in terms of that, my lord, the notice was published, that is at page 50, and the true copy I have annexed, that is at 50A. The notice was published on 10th February 2023, inviting applications, my lord.
Yes.
Yes, my lord. And it was stated, my lord, the third paragraph, consequent upon the verdict of mat number such and such, Swarup Bishwas versus Abhijit Ghosh, to fill up the vacancies arising in route number 30C/2, giving special preference to 20 annulled permit holders as opined by the Honorable High Court at Calcutta. So, my lord, we are the specially privileged applicant in respect of this particular route, my lord, because the route was introduced as per our prayer, because we have prayed for diversion of
Now, the writ petition involves the same route.
now, my lord, this petition involves the same route. They have challenged the resolution that was taken by the Regional Transport Authority on 19th January 2023. If your lordship kindly come to page 95 of the writ petition. And the type copy was given at 95A. General agenda number 3. Permits in the route number 30C/2 for 20 permit holders of the enhanced permit strength against the notification dated 17th June 2016. The Secretary RTA is requested to publish the notice accordingly. So, my lord, what they are trying to say, my lord, that new notification was issued. That was in 2023. And in that said new notification, it was specifically observed that only 20 number of permits, those permits were already annulled by the appeal court, they will get the preference and the permit will be issued in their favor only. So, my lord, this particular resolution was challenging the writ petition. Now, if this particular resolution goes, my lord, then my application, my endeavor for getting the new route, new application, because now vehicle is lying idle. All those operators have obtained the permit by purchasing a vehicle. Now, in my respective submission, my the division bench has said that the authority may explore the grant of permit by considering if the applicant has made their prayer for grant of permit from Hatiara to Satragachi via another alignment without touching the CBT. But in other hand, there was a direction that appellant before the appeal court, they can make their application for new grant of permit by variation of their route. And that was done by the applicant before your lordship. And in my respective submission, they are the, my lord, the necessary parties to the said writ petition, because if the order was passed against them, my lord, that will ultimately yours their right.
That's all.
Yes.
So far, we have heard from Mr. Nondi that his client has made the application in terms of the advertisement or notification dated 10th February 2023. Yes. Page 50A of the application addition of party.
Yes.
As regards the merits of the matter, I am not going into that, because that is the final outcome of the writ petition. Whether RT has taken the good decision or bad decision, I am not saying anything at the present moment. Your lordship, can you see, this is the notification for inviting applications. Inviting applications in respect of the persons who were already in the fray and who will be in the fray, both as per the order of the division bench. But here, will be on the fray is not there. Only in respect of that persons. And your lordship knows, I need not indicate that as soon as the application is filed, the application is placed before the RTA board for consideration. That is a quasi-judicial function by the RTA itself. And RTA, after considering the same, issued the offer letter. As soon as the offer letter issued, then the right accrues. Merely on filing application, right of a person does not accrue. They obtain the permit, their permit cancelled. The Honorable Court directed the authority to make take necessary steps for variation of the route. Whether it is a variation or not, that I am not addressing your lordship at the present moment.
That's on merits. Yes.
That is on merits. Number, if a person can be added as a necessary or proper party as per a civil procedure code law. As per the provision of Order 1, Rule 10(2).
So is it your case that the applicant will not be affected by the decision taken in the writ petition?
Yes, yes, yes. Because no right has been accrued in their favor. Has it been a case? Their application has been considered, offer letter has been issued, authority has taken a decision.
Their application has been considered and approved.
No.
Offer letter has not been issued.
No, nothing. Application has not been considered. Only they have filed the application.
The notification that you have challenged.
That notification is 19 January. And the invitation made on 10th February.
The 10th February notice refers to the 19th January resolution.
That's right. That's right. And 10th February is the invitation to offer. Authority has invited that you made the application. But if it is a case, it is a straight jacket that High Court said that these permits have been cancelled, you explore new possibility and accommodate them straightway in that permit, deleting the route and incorporated route. That is not the case. It is a fresh grant, new grant. So section 80 and other procedure has to be applied by the authority in proper perspective. Authority has to see whether these persons have fulfilled the condition for having a permit or not.
That is on merits.
That is on merit. So, this is only an invitation. No right has yet been accrued. I have made an application under Article 226 before the Honorable Court. Honorable Court did not pass any order till now. Has my any right has been accrued? May I put this question to myself? No. Number, your lordship has seen.
Mr. Chatterjee, there is an in-principle approval here. Only the offer letters have not been.
No. Application has not yet been considered. Your lordship kindly ask the RTA to produce the record that whether application has been considered in the board meeting or not. It has not been considered. Had it been considered, then notice would have been sent to Mr. Bundy's client that you appear before the board meeting for consideration of an application. I believe that has not been done. If it is, then I have no objection. Because that is the precisely decided by the Honorable Supreme Court as far as back in 1963, in 2018, 2018, both. Yes.
Yes.
Number, there is no right has been accrued. Number, notification has been published for inviting the persons. Notification may be cancelled. Your lordship has enough experience on this, that notification published for ration dealership. I made the application, notification cancelled at the instance of the existing ration dealer.
But here they have gone steps further, isn't it?
No,
Because-
only no. 10th February, your lordship, can you see? It is clear that they are to make apply. They are to apply.
The last date is 2nd March 2023.
Yes, 22nd March. No decision has been taken. Not a board meeting has yet been conducted. Your lordship, can you see that? ভাই এটা বাজাও কেন এখানে? অদ্ভুত ব্যাপার। Your lordship, can you see is application additional party page 50A, that is the notice inviting application.
58.
50A, 50A. 50 is the original copy, but it is not legible. That's why Mr. Nondi has made 50A. So 50A is the invitation. And the last date was 2nd March. And I moved the writ petition on 5th April. After 1 month, in each month, the meeting is conducted before the RTA. Normally in the last week of the month.
Yes.
Normally. RTA Calcutta is also took up the resolution in the last week of the month. They could have taken in the last week of March. No. No notice was also served them when the writ petition was filed. After writ petition was filed, then notice has been served on 2nd or 3rd April, most likely. I can give your lordship the exact date when this notice was served upon them. 1 minute. Your lordship kindly gives 1 minute to me. Without the evidence service. Yes. No, and I'm sorry. Writ petition was filed in the March itself, 3rd March.
Let us hear the state.
The third one. Now, my lord, I want to place two decisions.
Restraint order was passed on 5th April.
Yes,
Your lordship.
yes, it's 5th April.
For that reason, no board meeting was.
No. Board meeting could have been held.
How can it be, my lord?
Merely on the service of the notice, board meeting cannot be stopped. Board meeting is not being stopped.
Yes, my lord, because the
Counsel
matter is
says-
sub judice, my lord.
Learned
How they,
counsel says that your petition is premature.
how it can be, my lord?
That is your.
Yes, because no right has yet been accrued, and the Supreme Court in precise term,
Let me submit, my lord.
Supreme Court in precise term has said this. The person is the addition to be added as a party in a proceedings whose right has been affected.
Or may be affected also.
Not your lordship, can you see? কি হলো, বন্ধ করে দেবো?
Hearing matters.
If Mr. Basu requests me, I shall stop. I shall stop. I always obey him.
Let us continue because it will take some time.
Yes, it will take some time.
But,
But if your lordship continue it to tomorrow I have some difficulties because I am reading Mr. Nondi in another matter in court number 13. If it is takes up, then I cannot appear before
And
the
I'll
lordship.
give the date.
Yes.
but Friday, my lord?
Yes.
Friday, subject to your lordship convenience. my lord?
Friday, 1 minute. 1 minute.
Please come back next week. Next week.
Next week.
Yes.
My lord, today we are in 21st. My interim order is up to 31st.
Next Monday, lord.
Next month, 28th. Third learned counsels for the parties. Can one of them give it? Third learned counsels for the parties. Paragraph, let the matter appear under the same heading for further consideration on 20 August 28.
28th, my lord.
20.
Lordship.
Now, my lord, your lordship not extending interim order at the present.
It's still 31st.
It's still 31st.
Yes.
Let us hear it out on 20.
Because ultimately, one minute, Mr. Mitra. Ultimately, if your lordship allows this application, then definitely Mr. Nondi will ask for filing affidavit or anything. If he does not choose for affidavit straightway hearing, I have no objection. I am ready.
We'll come back on 20. Let us see what happens.
Lordship. Yes. Lordship. Grateful. Deeply.
Lord, I have already concluded my argument.
Reply. Reply cannot guarantee. Reply
Not
cannot
take
guarantee.
much time.
Half an hour.
Reply আধ ঘন্টা দিতে 1 ঘন্টা দেবে না এত বড় সিনিয়র আগে আছে এটা চলবে আমাদের আর ফাইলগুলো কোথায় এটাই জাজমেন্ট ফাইল দেখা
Yes.
I will reply. So I will not appreciate the everything, but I will only to give a step to the my conclusion. I will give some factual reminder to my. Now, when this matter was this dispute was cropped up, at that point of time, my lord, there was a clause of transfer, change of the purpose for which it was allotted. But subsequently, government has issued a notification by which the purpose allowed to be changed, transfer allowed to be effected. So today, it cannot be said that purpose has been changed, that's why you are debarred. Now the purpose for which it has been given, now has been allowed to be changed. This is
permission.
With permission. So there is the clause altogether. That I am submitting. This was not submitted by me at the time when I opened my case. But this is a case where the Social Welfare Board issued a tender. I am using the word consciously with the concurrence of the state government.
Yes.
Why I am submitting this, my lord? My lord will find the Social Welfare Board in every state inform the state government that we are going to do this. We have no money, so I have to go for public private partnership. Sometime your lords will find that no response. I have cited a judgment before your lordship. You are required to speak. If you don't speak, acquiescence comes. This argument of mine has now been crystallized to a thing when the late Justice Pratik Muker's Banerjee judgment said that you are the alter ego of the state.
Yes.
So whatever you have done, it should be construed to be done by the state government. If the state government has permitted me to take into consideration the judgment of Justice Banerjee, if the state government is allowed me to do this, whether my lord, the state government today come before the lords and say, no. I have made a mistake. Whether my lord, this is the sum and substance of the argument of Mr. Siddiqui that though it has been done by me, but it should not have been done. And our case is on that footing that on the basis of your assurance, we have altered our position. So section 115, our everything is squarely come. To that, my lord, I have cited 2-3 judgments, my lord. I will only remind you, lordship, my lord, the 2 letters of another thing, my lord, this agreement between us,
Social Welfare Board and ours for subject matter of arbitration. Arbitrator, not an arbitrator held that this agreement is valid. You have to perform it. If my lord considered that justice balances judgment, then this judgment, this arbitration agreement is against state. If the arbitration award is against state, then now by this process he cannot alter the judgment. He has to adhere to the judgment passed in the arbitration proceeding. But in any of the way, he cannot wriggle out from the fact that his liability, that he has put me in a condition by which I have altered my position detrimental to our interest. I have spent money, construction made, everything done. At that juncture, whether he can resume the land. When the decree or the arbitration award is against the state. The 2-3 letters, my lord, I will only demand to your lordship, nothing else. Just. Hardly, I will request your lordship to come to page 45. Already, my lord has marked that.
Of the writ petition.
Of the writ petition.
Yes.
56, 57. Yes.
Yes.
Kindly come to page 45.
Yes.
This is the letter of the government addressed to the Secretary, West Bengal Social Welfare Board. Allotment of land in Salt Lake for construction of hostel building for working women by the West Bengal Social Welfare Advisory Board. This is the first allotment. Now, my lord, kindly come to Lagben, Amar Omaik Kola. Kindly come to page 56.
Yes.
Kindly come to page 56. Third paragraph. It is dream of the board to construct the Bongo Hut and working women hostel. The board is writing to Joint Secretary. Kindly mark that. The accommodation of backward working women's hostel as achievement of the present government. But the cost toward construction is too expensive, and considering the fund crunch of our board, it is next to impossible to execute the development. Hence, the board has no other alternative to expect to participate in the PPP model, and it is quite obvious to construct the aforesaid. Within a very short period, our board directed to enter into the agreement PPP with the private partnership with Star Abasan. As per verbal discussion with you on such date, as development agreement is concerned, no NOC required from Urban Development Department, but for change of use of constructed area, except for which the land was allotted, NOC required after obtaining completion certificate from the concerned authority, and also necessary permission for sublease to be taken before it and time. We also applied to Central Social Welfare Board for approval of aforesaid PPP model project at Salt Lake. Next is very important. If you have any objection or any suggestions regarding our PPP model project, please inform immediately, as we have to start all necessary action regarding this project. After this, my lord, it suits in the mouth.
This is PPP model, not change of user.
Right.
They are alleging change of user.
That is also do, lords. Kindly, up till now, there is no objection. Very well, my lord, I am not addressing then so far as the PPP model. That is permit.
There is no dispute.
There is no dispute. Then, my lord, kindly change of user. Kindly see, the original allotment was for women's hostel. What the Social Welfare Board communicated to them, that they are going to construction a Bongo Hut. As my lord, 56 starts third paragraph. It is dream of the board to construct the Bongo Hut.
It was allowed by
Has my lord seen that? So original purpose for which it was given.
But objection and suggestion was called for only with regard to the PPP model.
But I am submitting, my lord.
That is only a statement.
It was informed to them.
That is a statement made in the letter.
So in both score, it was informed to them, we are going to construct a Bongo Hut, the dream project of the board, and PPP model. Both the last line suggests that kindly advise. If any objection, so objection in both. Can it not be construed as asking for myself, my lord, that in both score, the objection and suggestion was called for. Permission. Permission. Just in time, showing to lordship. That is also there. So Troy Malad has taken note of it. Agree. You want to give me minutes? Why not kindly come to page 83. Now the developer agreement with the modification witness. What has been modified? That the West Bengal Social Welfare Board will be entitled to the entire first floor and second floor of the said proposed multi-story residential building and the remaining constructed floor area including residential building will be at the sole property of the developer herein. So this why I am showing to lordship that this promise has been made and I have constructed on the basis of this promise and altered my position. Whether I am entitled to the benefit under section 150 or not. This is my lord. This is the case.
Page 33 of supplementary.
Second supplementary. Second supplementary.
Second supplementary.
Second supplementary.
First supplementary.
First or second?
First.
Yes. Kindly come to page 33 of this first supplementary affidavit. Somebody, I think my lord has taken a note.
I've taken a note. I've just seen that.
This is Government of West Bengal Urban Development Department. I'm reading for my lord. That is, this is referring to your letter. In respect to your memo number such and such on the subject noted above, I am directed to inform you that your office can use the for proposed working or hostel building such as Salt Lake as working woman family residential accommodation except 1 and 2 floor for
Spiral of page 33
aforesaid proposed building. So 1 and 2 is reserved for woman original purpose. For rest, I was allowed to convert. Subject by lord seat by lord seat that.
Subject is for
So original is proposed working woman hostel, and the now keeping that part for two floors, 1 and 2 floors, all are allowed to be converted. So my lord, there is no clog. All permission granted expressly.
Change of user granted.
All permission has been granted.
ও নিয়ে সমস্ত কাগজ চলে গেছে স্পাইরাল করে চলে গেছে
Granted permission. বাইরে আমি আর কি চাইবো?
So I think, my lord, I need not place anything on facts that
This is stated.
so far as the original purpose. Now I have shown that now the permission, previously there is a clock, no permission. Now the permission is, my lord, cleared by them. The field has been opened. Even then, prior to construction, my lord, my lessor in every step wrote to the state government, though he is the state government, wrote to the state government that is required your permission. Permission granted for PP model, permission granted for change of use. So express. So nothing, I have nothing more to show you, Lordship. I have cited one judgment for your Lordship's consideration. That is in 1960 Supreme Court. That they cannot now say that different stages of the proceeding, they should apply. Now they cannot reopen this. He is the state government permitted it. State government suffered a decree in the award or award. So now they cannot say by their conduct that I will frustrate the award without challenging it. On this, and these are all so far I am concerned. So I am trying to get the benefit of section 115 of the Act because I have altered my position. Now my learned friend has cited. My lord has taken note of that. Now, my lord, my learned friend has cited some judgment. My lord, I have to now only distinguish it. He has cited 1973 two Supreme Court cases 652.
Yes.
Has Manasali got it? And see the fact. He tried to distinguish that promissory estoppel does not apply against the government. This is the ratio of this judgment, where a post was created or a temporary post was created by the government of Andhra Pradesh for appointment of commissioner of the election commissioner or something like that. Just I am giving the chairman, a member of the board. Subsequently, my lord, government thought that this post is no more required, but there was an agreement with the person concerned that your tenure is 3 years. Prior to that, government thought in a policy decision that no, this post is no more necessary, so we'll abolish the post. Abolish the post. The gentleman approached the High Court and thereafter Supreme Court saying that there is an agreement. So, by virtue of your promise, I have altered my views. Supreme Court says, you came with the agreement knowing fully well that is a temporary post. You have no right. And the post has been abolished. Can you in this fact, I repeat, can you in this fact claim the benefit of 115? You have nothing altered your position. This is an employment. Offer was there, you are employed on a contextual basis. So that nothing like you can consider my case. On the basis of a promise, I spent a huge amount, constructed the building. And this is a promise expressly by the state. And this judgment says this is a post of temporary post which has been subsequently abolished. And accordingly, the Supreme Court held that no. Can we come to the paragraph 8, your lordship will get it the fact. Can we see paragraph 8, your lordship will get the fact. By an order dated, has Manasali got it?
Paragraph
8. By an order dated.
Yes.
By an order dated 24 February 1970, the government of Kerala stated that the post of Vigilance Commissioner sanctioned was temporary and the present sanction for the post of Vigilance Commissioner will expire on February 28, 1970. And that for the staff of the commission will expire on February 1971. The order further stated that the government, having considered all aspects of the matter, came to the conclusion that there is no need to have a Vigilance Commissioner. Government therefore ordered that the post of Vigilance Commissioner would be abolished with effect from 28 February 1970. The continuance of the staff of the commission up to March 1570 was sanctioned to enable the office of the commission to wound up by his work. It may be stated that here, that in the government order that is such and such, sanction for the continuance of the staff in temporary post from March 170 to February 21, 1971 was accorded. The affidavit evidence of the government of Kerala about the continuance of the temporary post in the staff of the Vigilance Commission till February 28, 1971 is that the budget for 1971 was prepared in advance of the preparation of the proposal of the legislature. At the time when the establishment of the Vigilance Commission, no decision had been taken regarding the abolition of the post of the Vigilance Commissioner. After taking the decision to abolish the Vigilance Commission, the government considered the feasibility of omitting the provisions of the budget, but it was found to be too late to make any change. The post of Vigilance Commissioner was sanctioned up to February 28, 1970. So this is a policy decision of the government that not to continue with the post. Whether, my lord, this judgment has any help to constitute 115 of the Evidence Act, where expressly I have altered my position detrimental to my interest. In this context, my lord, my humble submission, this judgment is not authority. So, proposition of 115 vis-a-vis the facts of our case. Then, my lord, 2018 12 SCC 85.
Yes.
Yes. My lord can remember, some retail outlets was granted by the ministers out of their own quota all over India. All were challenging Supreme. And the Supreme Court struck down. In this case, what happened? All allotments were struck down by the Supreme Court. What happened in this case? A lady obtained a retail outlet by that quota. The authority compelled him to purchase the property for the retail outlet. My lord knows, when the property, when the retail outlet is given, this land is taken on lease by the oil companies, and the dealer was allowed to run there with a lease rent. When the allotment cancelled, her allotment was cancelled. The oil company issued a fresh notification for retail outlet. The lady was not allotted, but the oil company forced her to give that land to the oil company so that they can run. The lady said, no, I will not, because I am not getting the retail outlet. Somebody else is getting the, how I can give this such a meager lease rent, because when I am getting from the retail outlet, in a meager sum I lease out. On that context, Supreme Court says this. That paragraph, kindly come to paragraph 22, 23 and 33.
Yes.
In the facts of the present case, we subscribe to the view of the High Court of Allahabad. With the termination of the dealership, the lease between the parties also stood extinguished, and therefore, the respondent being the owner of the land, she having expressed her disinclination to sell or part with it, the corporation by no means would have contemplated to award the new dealership to a third party on her land. On this clear promise, the failure of the corporation to act in terms of the directions contained in the judgment and order of the Delhi High Court, and in contending that the land of the respondent was available for commissioning the new dealership, is patently wrong, besides being continuously irrelevant and abusively non-complaint thereof. The approach and attitude of the corporation in making the advertisement dated such and such, with the corrigendum such and such, and in taking the apparently untenable stand that notwithstanding the cancellation of the dealership of the respondent, her land was available for the new process, is thus visibly mutilative of the rule of law, besides being destructive of the solitary object with which the High Court of Delhi had directed the cancellation of the dealership distributorships of the respondents, along with others, being vitiated by vice of nepotism and favoritism. This we say, as having regard to the progressive of events, we are left with the impression, in view of the present omission of the commission of the corporation, that it is not unlikely that all these might have been strategies or eventually benefited the respondent in long run. The pleaded stand of the corporation that despite the cancellation of the dealership of the respondent, her land was still available. Files in the face of the determination of the country as recorded in the judgment and order such and such, and only reflects the predetermined mind of his successor for reason unknown, though inferable. It is really impermissible as to how, in spite of such explicit and clear observation and direction of the High Court in Delhi in his judgment number such and such, either such a stand could have been taken on such fresh auction process could have been initiated without undertaking the initiative required for specifying, identifying the new location. To reiterate, no material has been placed before us to demonstrate to the contrary. This is more so as in the advertisement it is such and such, there is reference of the judgment and order such and such in the High Court. A bare perusal of the document would show that in view of the NH Patrimonial Character place Bostin of UP, the same is of the development of the respondent. Then, my lord, paragraph 23. It is no longer res intriga that a public authority, it was Reliance. He has relied on that. I placed before on these facts, this paragraph 23 has to be read. It is no longer res intriga that a public authority, be a person or an administrative body, is entrusted with the role to perform for the benefit of the public and not for the private profit. And when a prima facie case of misuse of power is made out, it is open to court to draw the inference that unauthorized purpose have been persuaded if the contemporary authority fails to adduce any ground supporting the validity of his conduct. This is, my lord, my learned friend has relied upon. But this paragraph 23 has to be read with paragraph 22, the facts of that case. And kindly come to 33.
Yes.
Jurisprudentially, thus, as could be claimed from the above legal enumerations, a public authority in his dealings has to be fair. I say this, has to be fair, objective, non-arbitrary, transparent, and non-discriminatory. The discretion vested in such an authority, which is a conglomerate of its power, is coupled with a duty and can never be under-regulated by unreviewed. Any decision or action contrary to these functional prospects would be at the pain of enumeration thereof. The state and its intermediaries, be it public authority, either in an individual or a collective, has essentially abide by the inalienable and non-negotiable prescription and cannot act in breach of the first report of the policy and no extraneous consideration. No allegation of extraneous. In exercise of uncontrolled discretion and power, it cannot resort to any act or fetter, order, and evolution and in public property, but it by way of state grudges or contracts, etc. Such outrages would clearly be unconstitutional and extensive of the rule of law, which forms the background of the constitution of the This paragraphs has to be read in the context of this judgment. And paragraph 33, as I have tried to convince my lord, is squarely in my favor. This is apparently arbitrary. This is, my lord, I am not saying discriminatory, but it is arbitrarily on the face of it. Next, my lord, my learned friend has relied on 2015 one Supreme Court cases 558.
Yes.
No, well, kindly come to city industrial developments. Here, my lord, the Supreme Court held that you cannot, by discriminatory attitude, you cannot allot the plot. This was the context of the city, the famous judgment, City Industrial Development Corporation. Kindly come to paragraph 54.
Paragraph
54. I will not waste you. The fact is this: the indiscrimination allotment was there, that was challenged, and Supreme Court said that anguish here, my lord, is clear. We take serious note and express our anguish. The way the authorities of CITCO showed undue favor to the respondents and managed to allot the government land in favor of one person, knowing fully well that the aforesaid proprietor of the company, in different capacity and in dummy names, short allotment of plots. The way SIDCO has been dealing with the government property, it is high time we observe that notwithstanding regulation 4 as contained in the regulation, the appellant SIDCO may take an endeavor to make allotments of plots by open tender or competing bids and shall not take any decision for allotment of the government land at the instance of the ministers and high dignitaries or any purpose whatsoever. Far difference, far difference. There, my lord, the nepotism is surfaced. That the Supreme Court says I have anguish. So here, my lord, nothing that type of case has been made out by the authorities. Then, my lord, 1993, na? Yes. But last time, my lord, he has shown 1993 3 Supreme Court cases, 499.
Yes.
So kindly come to 3 paragraphs, paragraph 33, 34, and 35. Oh, boro judgment. Kindly come to paragraph 33. I will place only 33. That will suffice. And we will be able to understand what is the ratio of this. On examination of some these important decisions, it is generally agreed that legitimate expectation gives the applicant sufficient local standing for a judicial review and that the doctrine of legitimate expectation is to be confined mostly to right of a fair hearing before a decision is negativing a promise of withdrawing and undertaking is second. Please legitimate expectation and promissory estoppel both sides. The doctrine does not give scope to claim relief straight away from the administrative authority as no crystalline right is involved. The protection of such legitimate expectation does not require the fulfillment of the expectation where an overriding public interest requires otherwise. Is there anything short to my lord? Or anything overriding public importance is given to negative my claim? In other words, when a person's legitimate expectation is not fulfilled, by taking a particular decision, then decision maker should justify the denial of such expectation by showing some overriding public interest. Therefore, even if substantive protection of such expectation is contemplated, that does not grant an absolute right to a particular person. It simply ensures the circumstances in which the expectation may be denied or restricted. The case of legitimate expectation would arise when a body by discrimination or by past practice assure expectation which it would be with its power to fulfill the coming. The protection is limited to that extent. The judicial review can be within those limits. But as discussed above, a person who bases his claim on the doctrine of legitimate expectation in the first instance must satisfy that there is a foundation and thus the local standard to make such a claim. In considering the same several factors which have rise to such legitimate expectation must be present. The decision taken by the authority must be found to be arbitrary, unreasonable, and not taken in public interest. I am fulfilling 3 criteria. Legitimate expectation would be these states are satisfied, and if the court is satisfied that a case of legitimate expectation is made out, then the next question would be whether various opportunity of they are not necessary because their hearing was not given. That was the legitimate that in this time. Showing this paragraph, my lord, these contents, college contention was that you have your legitimate expectation. But I say to you, from this paragraph itself, that I am fulfilling the 3 criteria laid down in this paragraph for having a legitimate expectation. Coupled with section 115, I am entitled to the relief I have made.
That's all.
Only if you require, my lord, I will remind your lordship the judgment of Justice Justice Focus Banerjee.
No, it's there. It's an order which is there.
Yes,
It's
I
part
have
of
started
the.
with 22nd July 2019.
Please have taken note of it.
Then it is that's all.
22nd July 2019. Yes.
That's all, my lord. I'm
Reserved.
grateful, my lord, for a patient hearing. That
Reserved.
one is always give. That's, I have to say this formally.
Argument concluded, judgment reserved.
কাগজ দাও না একটা নাম
নিয়ে নিন।
একটা কাগজ দাও না নাম দিয়ে
লেখা তো আছে।
ফাইনাল শেষ হলো
আলাদা আলাদা।
হ্যাঁ
ফাইনাল শেষ হলো।
এতদিনে মানে আপনি ইতি টানলেন বাপরে বাপ আমরা এতদিনে কিছু করতে পারছিলাম না
অনেকটা করে দিয়েছি।
There is another 330 matter.
কার সে?
106.
থানায় কিছু বলে গেছে সঞ্জয় ভট্টাচার্য হ্যাঁ থানায় কি বলেছে সিদ্দিক করবে
কত এটা 100? Yes.
This is relating to renewal of mining list.
Who is appearing for the respondents?
Mr. Siddiqui is.
Mr. Siddiq.
For getting renewal, my lord, this is the 5th writ petition. First, my lord, I preferred the writ petition. My lord, the renewal was applied for on 15th of December 1994. Challenging inaction, my lord, I filed the first writ petition. My lord, there was a direction. Subsequently, my lord, renewal was rejected. Then that challenging that order, I filed the second writ petition. Writ petition allowed, authorities were directed to consider. Again rejected. My lord, considering the 2011 amendment. Again, I challenge the order of rejection was set aside. There was a direction that it should be guided by the 2002 rules. Amendment rules will not be taken into consideration. Thereafter, my lord, again rejection. No, it was granted for 2 years. Instead of 5 years, 2 years. I filed a writ petition where, my lord, that liberty was given that I may pray for renewal of further 2 years after expiry. My lord, I preferred the appeal. During pendency of the appeal, my lord, the authority granted me the renewal for 5 years. It is at page 26. 23 is, my lord, page 23 is for 2 years. Page 23. This is memo dated 26th of February 2014. It was for 2 years. With reference to the application for renewal mentioned above, and to state upon the due consideration order as pleased to order the grant of renewal of mine entries for sand in respect of under mentioned area for a period of 2 years.
Page 26 is for 5 years.
Yes, page 26 is for 5 years. Therefore, my lord, I was directed to follow certain procedure for filing of draft deed for approval. I filed that. It was at page 27. Then, my lord, I was directed to file the final deed. It was approved. The earlier draft was approved, and I was directed to pay rupees 2,500. My lord, page 29.
Yes.
My lord, I have filed the 4 copies of original deed, my lord, and my lord, I have paid the money as asked for. That is at page 30.
Yes.
Therefore, thereafter, my lord, since nothing was doing, therefore, my lord, I made certain representations. Subsequently, my lord, by letter dated at page 33, I was directed to produce the environment clearance certificate. It is at page 33. My lord, I applied for at page 34.
Yes.
Then again, my lord, it was not considered, it was pending. I made an application under the Right to Information Act. Is at page. I made the application, my lord, at page 37. And Martin for Right to Information Act, what steps have been taken, that is at page 41.
Yes.
First query is memo number suggested regarding forwarding the form of was sent to the additional district magistrate Bankura have duly been received by you on what date? And second is what action taken? Well, the answer was he is not the SPIO under the district, therefore he will not given the answer. I made an application, my lord, before the authority that can you let me know who is the authority. However, on the next page, my lord, page 44, I made the application before the SPIO, which was, my lord, forwarded to the district land and land resource officer at page 45. Therefore, the SPIO forwarding my application to the district land and resource officer. And page 46, the district land resource officer forwarding the same to the senior GLS, before whom, my lord, I made the first application under RTI. Stating that he is to give the answer, therefore kindly direct the reply to the person. Thereafter also, my lord, I have not getting answer, but subsequently authority published a notice at page 47 for e-auction according to Rule 2016. My lord, I have challenged this auction when it can't be done, overlapping my area, applied area, because I have already get the grant of renewal that has already been given. My lord, I have
Your offer has not been cancelled, not been terminated.
No.
It is still existing.
Yes, but my lord, the final deed has neither been executed nor been registered.
Because
For
it was
want
waiting
of
for
my-
the environment clearance certificate.
Yes. And that application is pending before the authority, the district authority, the then authority. My lord, in my petition, I have prayed for prayers are at page 19. A reading the nature of mandamus commanding the respondent authority is concerned to issue environment clearance certificate in favor of a petitioner in respect of the mining list such and such for period of 5 years. Therefore, it is for environment clearance. Second is to complete the execution and registration. And prohibition is, my lord, not to give any, not to create any third party. My lord, in the affidavit in opposition, which is now, my lord, creating problem. It is at page 14, paragraph 7.
Yes.
Save as would appear from admitted record, save as specifically admitted by me, I deny that all the allegations that in paragraph 37, 38 of the petition, as in the same are set out and covered in reply to the corresponding paragraph. Process for issuance of environment clearance certificate to the petitioner was started after submission of requisite documents by him. But the district level environment impact assessment authority, that is the competent authority at the district level, who used to issue environmental clearance, is barred from issuing such certificate in terms of the office memorandum dated December 12, 2018, issued by the Ministry of Environment, Forest and Challenging Factor of South India, based on the order dated such and such of the Green Tribunal, And in terms of the state order, the certificate for the areas will be issued by state level environment impact assessment authority.
But this bar has been lifted now. This bar has been lifted now. It is not there.
Yes. Well, therefore, I have applied for the then authority. Now he is not the authority. My submission, the application, if the authority is changed, the authority should, the district authority should forward my application to the present authority, so that the present authority can take action and grant the environmental clearance certificate, and the authority who are competent to execute and register the document, that can be done. These are my prayer.
The e-auction process has been cancelled
It has
subsequently.
been stayed. It has been stayed by this honorable court.
Please come to paragraph 8 of the affidavit in opposition. Paragraph 8.
Have already cancelled this reduction, but my lord, before that, this petition was moved, and my lord, this honorable court, my lord, granted an interim order of stay. It is 10th of February 2018. My lord, two paragraphs are very important. At page 4 of that order, 10th of December 2018.
Page?
My lord, the order sheet, my lord.
No, it was
First order,
stayed.
10th of December 2018. In this matter.
December.
10th December 2018.
Where are the order sheets?
May I give it?
Yes.
Now, let's kindly come to the 4th page of that order. Second paragraph. The respondent authorities, it starts with
3rd page, yes.
the respondent authorities will not put the plot number to, this plot number is
2275.
yes. Mauja such and such police station Besnupur covering an area of 10 acres for auction, and will not create any third party right in respect of such part, save and expect executing the deed in favor of the petitioner till such and such. Subsequently, it has been extended time to time. It is still 31st of this month. Next paragraph is very important. This order will not prevent the authorities from executing the deed of lease in terms of writing dated March 2, 2016, and from considering deciding the application for grant of environment. In spite of this observation, my lord, they did not grant it, and my lord, they waited till the change of law. My lord, this order was passed. It was passed, my lord. No, my lord, my application is long back.
This can still be granted in your favor. Let us
Yes.
hear, Mr. Siddiqui.
Yes.
Yes. Since the subsequent auction has been cancelled,
Yes.
you have no apprehension at the
Madam,
moment.
madam.
Yes, Mr. Siddiqui. It is no longer a very
My lord,
complicated.
it's not very complicated, my lord.
Not at all.
My lord,
Yes.
I am stigmatized as an advocate for the state for the last 10 years. That I always vehemently oppose each and every writ petition, my lord. But being an officer of the court, it is my duty, my lord, with regard to this particular matter, that it is squarely covered by the proviso of section 60, rule 61 of the mineral constitution rules, where it has been stated, my lord, that book has been given. Provided possibly at page 67 of that book, my lord.
Yes.
provided that if the applicant has been issued a grant order, a letter of intent, or any other government order requiring the alteration of applicant's position, then his mining lease may be considered after due compliance of all the necessary conditions, my lord. Now, my lord, we have tried to vaguely, my lord, tried to elaborate the expression may consider his application. The word may is there. May consider his application in our affidavit in opposition at page 10. Paragraph K.
Yes.
It is submitted that the word may in the proviso to Rule 61 of the West Bengal Mineral Concession Rules does not make the proviso absolutely binding. There is an element of judicious application of mine at the time of considering pending mining lease application. In the instant case, though grant order was issued to the petitioner, still for execution of lease deed, or in other words, for carrying out a mining operation, environmental clearance certificate is a necessary prerequisite which has to be complied with. My lord, we have tried to jumble up two issues. Now, my lord, your lordship kindly do not record my concession, but in my humble understanding, he is entitled to get that, because the word is that if he has been issued any letter of intent or grant order, because that letter of intent or grant order was prior to 29th of June 2016 when this particular rules came into force. Now, my lord, the second issue is with regard to environmental clearance, which is a prerequisite in terms of the orders passed by the Green Tribunal, Learned Green Tribunal, as well as the Honorable Supreme Court in the case of Deepak Kumar. Nowadays, my lord, these particular environmental clearances are given by the Ministry of Environment, Forest and Climate Change of the Government of India in a portal called the Parivesh portal. But as far as I can recall, with regard to my earlier matter which I have done, it is given in Parivesh portal. So he has to get this environmental clearance, and your lordship may kindly direct the authorities concerned to execute the lease deed. This matter cannot be dragged. In my humble respectful submission, my lord, this matter cannot be dragged. But the environment,
So,
my lord, kindly do not record my concession, my lord, but your lordship may kindly, my lord, appreciate, but environmental clearance is a prerequisite for carrying out the mining operation, my lord. Without that, he cannot carry out the mining operation.
Question is whether that application will be forwarded to the.
No. You have to apply afresh.
And that application has to be made in the Parivesh portal of the Ministry of Environment, Forest and Climate Change of the Government of India.
So let this be recorded, Mr. Siddiqui. This part of your submission be recorded, because
Without that, he cannot do.
heard learned counsels for the questions. The petitioner seeks a direction upon the concerned authority to issue environment clearance certificate in his favor and execute and register the deed of lease for a period of 5 years. It is in fact a renewal. Sure.
Yes, renewal.
It is a renewal of paragraph. Initially, a mining lease was granted in favor of the petitioner, which expired due to efflux of time, and the petitioner applied for renewal thereof. The prayer for renewal was initially turned down by the authority, and upon intervention of this court, the authorities renewed the lease for a period of 2 years, which was subsequently revised and a renewal for 5 years was granted in favor of the petitioner. Stop. The petitioner applied for environment clearance certificate which is yet to be issued.
আর তো কিছু হবে না, 4:30 হয়ে গেছে।
The paragraph. The fact of the entire case has been recorded by this court in an order passed on 10th December 2018. Wherein this court restrained the respondent authorities from putting the plot in question for auction and creating any third-party right in respect of the same. The order records that the authorities are not prevented from executing the deed of lease in terms of the writing dated March 2nd, 2016, and from considering and deciding the application for grant of environment clearance. Stop. Paragraph. The proviso to Rule 61 of the West Bengal Minor Minerals Concession Rules, 2016, envisages that if the applicant has been issued a grant order or letter of intent or any other government order requiring the alteration of the applicant's position, then his mining lease application may be considered after due compliance of all necessary conditions. Stop. Needless to mention that issuance of environment clearance certificate is a prerequisite to execution and registration of the deed of lease in favor of the petitioner. Paragraph. Learned counsel for the state respondents submits that the petitioner may apply in the Parivesh portal. What is the exact?
Parivesh portal of the Ministry of Environment, Forest and Climate Change.
Parivesh portal of the Ministry of Environment,
Forest and Climate Change.
Forest and Climate Change,
The government of the Government of
West
India.
Bengal, huh?
No, of the Government of India. It is the central
Oh,
portal.
of the Government of India, climate change. Ministry of Environment,
And
Forest and Climate Change.
It is written as MOEFCC.
Okay. Environment for change of the Government of India for issuance of environment clearance certificate in his favor. In view of upon consideration of the submission made on behalf of the parties and the law on the point, comma, this court is on law on the point, comma, this court is inclined to hold that keeping the writ petition pending shall not serve any fruitful purpose
সার্টিফিকেট ওরা দেবে না না এটা এটা শেষ হয়ে গেছে এটা চেঞ্জ হয়ে গেছে
stop accordingly, comma, the petitioner
টোটাল হয়ে গেছে
is at liberty to apply in the Porivesh portal of the Purota Devan for issuance of environment clearance certificate upon compliance with necessary formalities. Upon compliance with necessary formalities within
4 weeks. Within 4 weeks.
4 weeks, within 4 weeks from date, stop. Upon the petitioner submitting the said certificate before the concerned authority, comma, the authority being the respondent number,
it will be respondent number
should be the ADM DLL or
ADM and DLR
sixth respondent, being the sixth respondent here in comma, is directed to execute and register the deed of lease in favor of the petitioner, subject to the petitioner complying with all other requisite formalities within in favor of the petitioner বললাম deed within 1 month ওখানে in favor of the petitioner ওখানে করুন within 1 month from the date of receipt thereof, subject to the petitioner complying with. ঠিক আছে 4 weeks and another 4
other 4 weeks
with the above instruction.
ওরাই গাইড করে দেবে ওরাই গাইড করে দেবে কিভাবে অ্যাপ্লাই করতে হবে
আছে কি
না না করে দেবো তো বলে দিয়েছি আপনি জমা করবেন সার্টিফিকেট ওরা করে দেবে আর এখন সেন্ট্রাল পোর্টাল হয়ে গেছে তো তাড়াতাড়ি হয়ে যাচ্ছে
disposed of no order as to cause or administrative website copy affidavit আছে এটা এটা হবে না hearing letter.
My lord, with regard to item number 99, may we file a written notice matter was concluded? Mother side is here.
Which matter?
The earlier matter, Mr.
Basu.
Shaptanshu Basu
Not
appeared, my lord.
necessary. Why? Not necessary. After so much of arguments, no written notices.
If required, but it was just.
No, not necessary.
Grateful, my lord.